This is the Carver Zoning Board of Appeals, and we welcome everybody here tonight. This is far more people than we're used to seeing, but we're happy to see you all. Happy to have you interested and participating in tonight's events. Tonight is May 23rd, 2013. We are being recorded tonight by, among others, Carver Community Access Television, CCAT. I think that's a first for this board. We welcome them. We're happy to have them with us tonight. The first thing on the agenda for this evening are the minutes. I want to go to the minutes first so that we can address that administrative issue before we get to the major issue for this evening. So I would ask the board members who are present to pull the minutes, get them in front of them, and take a quick look, make sure that they are accurate to the best of their memory. These are, again, last month's meeting minutes.
2 months ago, actually.
Ms. Clark, are you good? You read yours already? You're good?
Good.
Mr. Mueller? Mr. Nowlan? Ms. Moniz? Mr. Collins, need another minute?
I'm all set.
Do I hear a motion?
I move we approve the minutes of the Zoning Board of Appeals for the March 14th, 2013 meeting as written.
Do I hear a second?
Second.
Any discussion? Hearing none, all in favor?
Aye.
Okay, then let us proceed with dispatch to the major business for the evening. And I think probably the best thing to do at this juncture would be to read the public notice into evidence so that everybody can be absolutely certain what it is that we're going to be talking about tonight. This is case number 12-958. The petitioner is Rocky Meadow Development Corporation, Barry McNeil, care of Shepard S. Johnson, Jr., Esquire of Shepard S. Johnson, Jr. and Associates, P.C. at 528 Pleasant Street, Suite 428, New Bedford. This is with regard to property located at 0 Purchase Street, aka 12R Great Meadow Drive in Carver. The applicant is appealing the building commissioner's letter dated April 3, 2013, withdrawing the building permit. That is permit number 2013-50, certifying that Noel Southgate, holding CS license number 98020, has permission to install 4,160 solar panels located at 12R Great Meadow Drive, map 55, lot 1-0, issued on March 12, 2013, and issuing a cease and desist order. The property is zoned a residential agricultural district in accordance to Town of Carver Assessor's map 55, lot 105, 107, 1-6A, and in accordance to the Town of Middleborough Assessor's map 55, lot 1-0. Phew, that's a long one. Okay. It is not lost on this board that there is considerable public interest with regard to this case. So for those of you here tonight, and also for those of you watching at home, allow me to make some introductions. First to my left, in that pretty pink blazer, is Fran Modes, who comes to this board with considerable business experience and background on a management level. Sitting to her right is Mr. James Nowlan, who I consider sort of our green guy. He's our environmental expert and sits, as some of you may know, on the Conservation Commission. To my immediate left is Mr. Eric Mueller, who many of you may know from his trucks around town, Southeast Septic. He has his own business in Carver. Septic guy, very well versed in septic issues as well as in Title V issues. To my immediate right, this handsome gentleman here with the black suit, I think we must have coordinated on our attire tonight, that's Mr. Greg Corbeau from Copeland & Page. He's legal counsel for the town. Next to him is Sharon Clark, who is our most senior member. She probably resents me saying the most senior member. but she has considerable experience with titles and real estate issues. She has run many titles both in the Commonwealth of Massachusetts and in the state of Rhode Island. She's very good with plans as well. Her experience has been invaluable to this board. Next to her right, is Mr. Walter Collins, who comes to this board with years of experience in the building and construction trades, obviously useful to this board. And sitting to his right is our clerk, Deborah Carlino. I can be accused of bias for saying what I'm about to say next, but I plead guilty. I think this board, with its breadth and depth of experience, is one of the strongest boards that any town or municipality could have with regard to zoning issues. I'm privileged to serve on this board and privileged to serve with these folks. Now, I'd like to make some opening remarks about this case, sort of to set the table for what's going to be transpiring this evening and probably in future meetings as well. This case has been heard already by various Town of Carver boards since July of 2011. Seems like 2011, when the original site plan was submitted to the planning board. Now, by my count, the planning board has conducted no less than 5 public hearings with regard to this project and also conducted a site walk. The Conservation Commission held 6 public hearings by my count and also 2 site walks. The Board of Selectmen held a meeting which was specifically designed to hear from concerned residents in the town of Carver as to the merits of this project. The Earth Removal Committee has been involved, and of course our building commissioner has been as well. So I think that we can all agree this evening, or we should be able to agree as reasonable people, that a lot of time and energy has already been spent by town personnel and town boards with regard to this project. I think it's equally important to recognize that a lot of time and energy has been spent by the opponents of this project trying to get their voices heard. So tonight with this board, the Carver Zoning Board of Appeals, the buck stops here. For tonight anyway, the buck stops here on the local level. I hasten to add, however, that it's unlikely that we're going to be finished with this case tonight. There is a lot to do, there's a lot to hear, and I suspect that one or more members of the board will probably want to conduct a site visit after we conclude this evening's proceedings. Parenthetically, it has been brought to my attention that some people may be operating under the misapprehension that the Zoning Board of Appeals, this board, has already heard pieces or part of this case. That's not true. Completely untrue. And that is why we need, because it's coming to us fresh tonight, why we need to start from scratch. And we'll need to have sufficient time to hear all the evidence. And that's important, ladies and gentlemen, and also for you watching at home. This is an evidence-taking board. And as such, just like trial courts do, we are obliged to hear all the evidence, sift through it, and then make a decision in accordance with the law, both Carver bylaw, local law, state law if applicable, and even federal law if applicable. The issues in this case are, by all accounts, complex. They touch on public safety and health and welfare issues. These intersect with the scientific. And finally, in some respects, we have novel legal issues present that bear on both local and state public policy as applied by the local Town of Carver bylaw and also as codified in the Massachusetts general laws, state law. So it's a lot of stuff. And I guess that's why we're getting paid the big bucks. So I want to start with a couple of pertinent dates to kind of get us off, hopefully, on the right track. The first date being March 12, 2013, which was the date, in this case, that the building permit was issued. And also the date of April 3rd, 2013, when the building permit was revoked. So at the outset, I would ask that the building commissioner, if he is present, to approach the table. Is he here tonight? I see somebody moving over there, but I guess that's not the building commissioner. I had a few questions for the building commissioner, and it's regrettable that he isn't here this evening. Perhaps we can get him to respond at a subsequent meeting. Next, I'd like to have the project folks and their attorney approach and sit at the table so we can go over a few things. Well, if we know how to do it, then yes, we can do it.
I don't think we have the authority, but I think the guy closest can probably do it. It's over there.
Okay.
Could you just explain who the voting members are on the zoning board for this case?
Yes. Voting members are Mr. Nowen, Mr. Mueller, Mr. Gray, Ms. Clark, and Mr. Collins. All right, gentlemen, would you please introduce yourself?
Thank you very much, Mr. Chairman. My name is Shepard Johnson. I'm attorney representing the project proponent, Rocky Meadow Development and Brago Power. And with me here is Richard Rium of Prime Engineering. He's been involved with this project since the beginning through all the stages of permitting prior to this hearing.
Have we met before, Mr. Johnson?
I believe we have. It's been some time, however.
You look vaguely familiar. Nice to see you, and welcome to you both.
Thank you.
To kind of get the parameters of the legal issues outlined for everybody, and hopefully to get those legal issues narrowed, I'd like to kind of walk you through a couple of things if possible and ask you a few questions and open things up to board members as well. Is that okay?
That's fine.
Okay. I guess the easiest thing that we may attempt to address tonight is whether you're prepared to agree that the site of the proposed project is zoned RA, residential agricultural. Can we agree on that?
Yes, we can.
And do the board members have any questions or concerns about this property being sited in our RA district? In other words, the classification. I'm just talking about the classification for now. We all good with that?
Yes.
Okay. So the next thing I want to have you address, Mr. Johnson, and or your client, is can you identify for me what use you're intending to put this property to? How would you characterize or label that use?
Large-scale solar photovoltaic array.
Is it an industrial use or an agricultural use?
It's actually neither. A review of the code of what is classified as industrial use doesn't fit any of the classifications in the zoning code. It also doesn't apply to any of those in commercial or residential. It's simply silent on the matter.
Mr. Johnson, do you want to add anything to that?
Excuse me, Mr. Gray.
Yes.
I'm sorry, could you gentlemen speak up just a little bit more?
Oh, sure. Oh, sure.
I have a blower right over my head.
I'd say it louder. The zoning code in Carver has a list of things that they consider to be industrial, such as a manufacturing plant, a assembly building. And when you go through each of those industrial uses, solar is never mentioned. It's also never mentioned in any commercial use or any residential use.
So is your position tonight that the project can't be labeled or characterized in any fashion?
Well, I'm sure people will try to characterize it however they would like to.
You have submitted to the board, and I thank you for doing this, a 8-page letter. And I note that on page 5 of your letter, Mr. Johnson, you take a stab at labeling or characterizing this property as being more akin to agricultural activity as opposed to industrial. Can you talk to us about that, why you appear to want to take that position?
Sure. Can you hear me, Mr. Collins? Okay. I guess I view agricultural activities as, at its most basic root, transfer of energy from the sun into another form of energy, essentially trying to harvest the sun. And agricultural activities generally harvest that sun by creating a plant, and the plant is then used in some fashion. The plant is what stores the energy and processes the energy from the sun, and essentially that's exactly what a solar panel does.
So, by this manner of thinking, you are suggesting to the board that this project is more akin to an agricultural activity as opposed to an industrial activity. Is that what you're trying to tell us?
Well, I think that the words that I use speak for themselves. What I think Mr. Reum pointed out fairly correctly is that this type of use is not described in the town's bylaw at all. Yeah. Do you agree with that, or?
There was a period of time in this town that we did not have a solar bylaw, as you well know. Now we do. But I want to get back to the question of how we characterize this use. I view that, personally, I view that as an important issue. And personally, and again, just speaking for myself, I have an issue thinking about this project as more akin to an agricultural activity than an industrial activity. And I'll tell you why. When we think of something that's industrial in nature, we think of something which is manufactured or produced or processed. When we think of agriculture, at least when I do, I'm thinking of typical farm type activities where people are raising livestock and growing things. Now, under the Massachusetts general laws, agriculture is defined throughout in various chapters. I want to draw your attention and the members of the board's collective attention to Massachusetts general laws, chapter 128, section 1A, which is in the agriculture and conservation chapter. And agriculture is defined therein as farming in all of its branches, and the cultivation and tillage of the soil, dairying, the production, cultivation, growing, and harvesting of any agricultural, aquacultural, floricultural, or horticultural commodities, the growing and harvesting of forest products upon forest land, the raising of livestock, including horses, the keeping of horses as a commercial enterprise, the keeping and raising of poultry, swine, cattle, and other domesticated animals used for food purposes, bees, fur-bearing animals, and any forestry or lumbering operations. We also see agriculture defined in the Massachusetts general laws under the Massachusetts Endangered Species Act, Chapter 131A, where it talks about land in agricultural use, defined as land primarily and directly used in raising animals, including but not limited to dairy, cattle, beef cattle, poultry, sheep, swine, horses, ponies, mules, goats, bees, and fur-bearing animals. So, I don't know how the rest of the board members feel about this, but when we get to this question about how this use is to be characterized, and I think that's important in arriving eventually at how we're going to decide this case, in my opinion, based upon definitions as provided in the Massachusetts general laws, and also commonly understood definitions of what an agricultural use is versus what an industrial use is, in my opinion, this project smacks far more of an industrial use than it does an agricultural use. Gentlemen, ladies?
Absolutely.
Can I just say one thing about reactions and clapping and so forth? Thank you for that, by the way.
Yeah, we're really not used to that.
That was very nice. But this is not a political rally, and I know that passions are running high on this issue. So if you could endeavor to sit on your hands tonight and just let us proceed as quickly as we can through all of this material, I'd be most grateful. Again, thank you, though, for the clap. Board members?
I think when you're talking about akin to agricultural activity, this solar array, this solar farm, you're going to sell the electricity? Your plan is, the plan was to sell the electricity, or,
That's correct.
so is this the same as selling squash? Is that what you're trying to make? If this was a cornfield?
Well, you could certainly look at it as a, however you'd
I
like.
want you to tell me how you look at it.
Well, I guess one of the things that when I look at this project, in terms of those things, I look at it as, over the life cycle of this project, it's akin to planting 450 acres of trees in terms of the benefit to the planet with respect to global warming and CO2. It's akin to taking 200 cars off the road permanently. It's akin to a reduction in CO2 emissions of 50 million pounds. It's going to reduce nitrogen oxide and sulfur oxide emissions by 50,000 pounds and 100,000 pounds respectively. It would take over 75,000 barrels of oil. 75,000 barrels of oil burned to get the equivalent energy of what this solar farm will harvest.
Okay, that's not what I asked. But thank you for that. I mean, I'm 58 years old. I grew up in the green era. I was in high school for the first Earth Day, so I understand and I appreciate everything that you just said. However, we're talking about this project sited where it is. And when you're talking about it being akin to an agricultural project, when I plant a field of corn, not that I ever have, but if I did, I would not, try to sell my corn by saying, well, this is equal to X number of carbon units in the atmosphere or something like that. So you're coming at it as this is an agricultural activity. So I almost want to ask you if you can take the science part out of it, that section of science that you just talked about, cars on the street and things like that, because that isn't akin to what you're saying. So you're selling the electricity that's produced by the solar farm. How is that the same as an agricultural activity?
Well, I tried to explain myself earlier in terms of harvesting the energy from the sun, which is what, with the exception, of course, of livestock raising, most agricultural activities involving the raising of plants, the entire economy of that operation is based on harvesting the sun. Usually, it does not involve lots of mechanized equipment. Sometime,
I would say generally it doesn't. When my field of corn harvests the sun, all it has to do is grow.
exactly. As opposed to an industrial operation, where an industrial operation you have people coming and going, you have a bunch of workers, you have the manufacture of something. Usually it involves bringing materials to a location and transferring it into some other type of product. It's heavy in terms of comparatively heavy, as you will see from the way zoning has evolved from the very beginning, trying to put industrial activities in a location that are separate from other uses that are dissimilar, because it's recognized that while we do need manufacturing activities of typically of an industrial nature, such a use usually involves lots of traffic to and from to bring the materials in, lots of workers there. It characteristically and historically involved emissions to the air. It involved discharges to the groundwater or to surface water. It involved a lot of externalities that were negative, that were more detrimental to the neighborhood. And one of the other things, those are the things you do not see that in this type of a solar farm. You have solely harvesting the sun. Once this is installed, you're not going to have comings and goings. You're not going to have emissions to the air. You're not going to have any emissions to the water. You're not going to have noise. You're not going to have any of the externalities that are generally associated with industrial activities of the type that have encouraged zoning in the first place, to try to keep uses consistent and try to put those types of uses in locations where they would not cause harm. One of the other things that industrial operations, they often do not have a direct benefit for a town or for the area that they are established in. And today's manufacturing, for example, often is worldwide. But one of the things that is similar with agriculture and a solar farm is that the zoning laws in Massachusetts, the Zoning Act itself, and historically the evolution of the controls of land in Massachusetts dating back to the 1800s encourages both agriculture and solar.
Could I interrupt just for a minute, because I think we're getting off the sort of directed question that I was trying to put to you, which is...
She put the question,
She did.
and
Okay.
I thought I was answering her question.
And I think she was following up on mine, but I want you to bounce back, if you can, for a second, and talk to me about how you see this more akin to an agricultural use, when it doesn't seem this project to fit into any of the statutory definitions of agriculture in the Massachusetts general laws. How do you get past that, counsel?
Well, I would note that the Endangered Species Act definition that you read to us didn't even mention plants at all.
I also...
There are so many definitions of agriculture in the Mass General laws that you could pick and choose among hundreds. And I submit to you that that kind of selective picking and choosing is inappropriate in this form.
Okay. Well, I appreciate the creativity of your argument. It's a non-starter for me, however. I think what we can see in all of these statutory definitions is a common theme, and that is that people who are engaged in agricultural activities are engaged in doing something with an organic organism, something that's alive, whether it be animal or plant-based, or even insect. That theme runs commonly through the definitions that I viewed in the Massachusetts general laws. This project seems to be more in the nature, in my opinion, of an industrial use. And again, I'll step back for a minute and
I do have one question.
Yeah.
Has the term solar farm ever been defined as agricultural in the Mass General Law definitions anywhere, even under the solar bylaw or even under the solar laws? Have they ever used the term solar farm as an agricultural definition?
I do not believe that, with the exception of the provisions that I cited to you, that the zoning act refers to solar in section 3 and in section 9, and that it is a relatively new technology, and that it is essentially, I'm trying to answer questions about what it's more akin to, and I'm trying to address the things that the Zoning Act is designed to address, which are the health and safety and welfare of the general population. And from the 1800s, Massachusetts has recognized that access to solar, access to the sun was an important thing to protect. As early as 1985, Massachusetts is one of the first states, I believe it may have been the first state in the country, to enact in its zoning act a recognition of the importance of access to the sun, and specifically to include a provision that is very much like agriculture in the way that the Zoning Act treats it, as follows. Agricultural activities may not be prohibited virtually anywhere because it's societally a use that is favored, a use that is encouraged, a use that is widely recognized as important to the planet. I suggest to you that the same holds true for solar. In 1985, the legislature essentially said no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems or the building or structures that facilitate the collection of solar energy, except where necessary to protect health, safety, and welfare.
And I assure you,
Just excuse me.
go ahead.
That's essentially the same type of encouragement that agriculture has in the Zoning Act. And that's why I say it's more akin to agriculture than it is to industry. And if you want to look at the definitions of industry, Mr. Chairman, I am sure that you will find nothing similar to what you have with the solar farm.
The Town of Carver bylaws has a table of uses, which I'm sure you've reviewed. Where does your project fit?
None of the uses in the town's bylaw that apply to this case mention solar at all. And more specifically, what I'd like to say is, and I, you know, perhaps this board could acknowledge that we are here dealing with the town's bylaws as predated at the time these projects were filed, not the new solar bylaw. We're dealing with the bylaws in town that were in effect at the time these things were filed. Does everybody agree with me on that?
Well, let me kind of walk us to the next point that I want to go over, and I assure you we'll get to that one because it's coming up pretty soon on my list of questions here. Before I get to the next point, though, does anyone else on the board have any questions or comments with regard to agricultural versus industrial use of this project as presented?
I'm good.
Okay.
I do. I want to back up to a statement that you had made when you were trying to give us your classification of what solar project actually is. You stated that industrial use is something that basically generates a product out of another product, and you said that the solar farm basically takes the sun and absorbs that, and there's no process involved in that? You just have the sun and its energy?
No. As you point out, the important feature here is just like a plant, if you want to stay on this topic, trying to compare it to one versus the other.
I can see what, I'm going to interrupt you, I can see where you're going with that, but the thing is the plant doesn't need people to change it to actually become something. Solar energy needs to come from the sun, but we need to do something with that to create energy out of that. So to me, that's more of a industrial or commercial production rather than an agricultural.
Well, I understand your point. I guess, we have to constantly evolve as persons on this planet trying to keep it safe. And one of the things that's kind of interesting is you look at technological change. Many years ago, we might not have thought that machines could think or process or be intelligent. But we now know that there is artificial intelligence, and that scary artificial intelligence in some ways. And so, those are things that we only used to think people could do.
I have to disagree with you there, because to create artificial intelligence, it takes people to create that, and it will only think as far as the creator will actually produce it to.
Any other questions or comments from the board at this point? Mr. Now.
I want to say, based on my experience as a young man in my late teens, I was heavily involved in agriculture out in Western New York. I picked tomatoes and potatoes, and I worked part-time in a canning factory, and I cleaned dairy barns. And I think that to say that agriculture is so different in that you simply have plants growing is pretty simplistic. The plants that we depend on for our food nowadays would not grow without massive amounts of human intervention, as far as the quality of the plant, as far as the nutrition which the plant draws on, and also the handling and preparation. Now, we have people who buy food from farm stands, that's one thing, but to really supply people with food to a large degree involves mechanized agriculture, involves the use of heavy equipment, very noisy machinery. It involves the canning plant where I was at, which is actually a really dangerous place to work. People every day were cut by flying pieces of metal occasionally. It was not a happy thing. I left after a couple of months. And I just think that to say simplistic that it's just plants growing, that's agriculture. No, agriculture is an industry in its own way. So I consider this adaptation of the use of land to be much more benevolent and much less socially demanding than normal commercial agriculture.
Any other questions or comments from the board on the issue of agricultural versus industrial use for this particular project? If not, Mr. Johnson, I want to direct your attention to a comment that you made a couple of minutes ago, which I promised I would get back to. And that is, you began to talk to us about why you believe that the current Carver solar bylaw is not applicable to this project. You speak to the board why you are taking the position the current Carver solar bylaw is not applicable under these circumstances.
Is there any disagreement about that?
I'm asking you a question.
Well, it's a straight legal question. I don't think that in fact, I think to the extent that anybody suggests to the contrary, any such suggestion would be taken in bad faith. I think it's quite clear from a legal perspective that when this project was filed, there was no solar bylaw. I think that there was an approval not required plan that was filed that froze the use in the zoning that existed at the time. Colloquially, lawyers refer to these as zoning freezes. I believe the town has received an opinion from town council to the effect that, yes, zoning freezes do occur on the filing of an approval not required plan. Similarly, upon the filing of a preliminary subdivision plan, prior to the date of the notice of a bylaw and hearing, followed thereafter by a definitive subdivision plan within 7 months. Two different methods to create zoning freezes, which I think are quite clearly applicable in this case.
Mr. Corbo, do you have an opinion on whether the zoning freeze under these circumstances applies?
Thank you, through you, Mr. Chair. The applicant is correct in some respect that there are certain freezes that go into effect when actions are taken prior to the effective date of a zoning bylaw. However, I think it's the function of this board here tonight to make a determination as to which version of the bylaws they are to review this project under. And therefore, I would recommend to the board that it take evidence to either prove or disprove whether or not these zoning freezes do in fact apply, so that there can be a determination of which zoning bylaw the project is subject to.
So, Mr. Johnson, I bounce this back to you. At what point are you suggesting to this board that the zoning freeze to which you're referring came into effect?
The freeze came into, there are two different freezes that apply here that came into effect at different times.
Can you
And I
give us
would-
the times?
Yes.
Thank you.
On October 24th, we submitted a Form B, which is a preliminary plan, filed it with the planning board and with the town clerk.
That was 2012?
That's correct. And we can provide you with a I don't have it with me this evening, but the town clerk obviously has it, and planning has it, and I can provide the board with a copy of that. And then we subsequently, this May, prior to May 25th, submitted a definitive plan to the town clerk, and it was accepted by the planning board.
What date was that again, please?
I don't know.
Sometime in early May,
Yeah, sometime in early May.
before the 24th.
Right, in the-
Of this year?
Of this year. Less than 7 months, obviously. And the planning board has a standard protocol that they receive the plans at one of their regular meetings. So the day before yesterday, at one of their regular meetings, they officially accepted that definitive plan submission. So that puts the original zoning bylaws in effect. And that's obviously the matter which you should be considering, because if the new bylaws were in effect, this plan doesn't meet the criteria for the new solar bylaw, so we would have to resubmit and go through the process with the Planning Board and Conservation Commission, and be no reason for you to hear it.
And you would require a special permit if that were the case, correct?
That's correct. And we'd have to meet the new setback requirements from property lines and the like. So it would require a redrawing of the plans. So it's inappropriate for the board to be looking at a plan that's not before the planning board.
So
There
based
was
on...
if I may also?
sure.
There was also a separate zoning freeze for the use that applied upon the filing of the Form A approval not required plan. If you give me a moment, I'm sure we'll come up with the date of that.
Please.
But I'd also like to note, you mentioned the new bylaw. It's interesting that this type of use is allowed in the agricultural residential district.
With the precondition, right?
Oh, plenty of preconditions.
The primary one being that you would need a special permit. Correct?
I have not looked deeply into the new bylaw, as it clearly does not apply in this case. And I would reiterate my position that any suggestion to the contrary would be made in bad faith
By whom?
by whoever makes it.
Do you have a date for the site plan approval?
The approval not required plan was submitted to the planning board on November 15th, 2012. Oh, I'm sorry, I'm sorry. It was submitted on October 24th, 2012, and discussed on November 15th.
So that's the date on which you say a zoning freeze came into place with regard to use. Is that true?
The Form A freezes the use, the Form B freezes all of the zoning standards in effect at the time of town meeting.
Such as dimensional requirements.
That's correct.
So we're talking about two dates here, the 24th of October 2012, and I'm not sure that I got the other date.
I believe they were submitted on the same date.
October 24th, 2012.
For,
And that, for the approval
Site
not
plan?
required Form A plan.
okay. And what about the Form B plan?
Same date.
Same date, okay. Do any board members have questions with regard to this discussion that we've been having with regard to the solar bylaw and the freeze, which the project folks are saying is applicable to this situation, thereby making the solar bylaw that was passed inapplicable? Hearing no discussion, let me weigh in on this point. We have three lawyers in this room tonight, at least three that I know of. And at 7:48 p.m. on May 23rd, 2013, we have three lawyers all agreeing on the same point. That's remarkable. So personally, I don't have any feeling that the Carver zoning bylaw, in this case with regard to solar, applies to this situation. I believe that there was a freeze in place. I needed to hear your explanation of that. And now that I've heard it, I want to ask you this question. This use to which you want to put the property, you acknowledge is not listed anywhere in the table of uses that existed prior to the passage of the solar bylaw. I think we can all agree to that. If that's the case, why is this project not prohibited under bylaw 2210, which says that if a specific use is not identified in the use and regulation table, it's not allowed, period. Black and white. Talk to me about that.
I'll read to you again, Section 3 of the Zoning Act, passed in 1985, Mass Acts, Chapter 637, Section 1. No zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems or the building of structures that facilitate the collection of solar energy, except where necessary to protect public health, safety, and welfare. Your own town council originally cited this provision as the basis for his opinions supporting this project. I would suggest he is in good company. In every single municipality, Commonwealth of Massachusetts, town councils have similarly cited this provision as the definitively applicable provision. So you can't prohibit solar. I would go further
Could I
than
just
that.
stop you there for a second? That last comment was interesting to me. You said you cannot prohibit solar. Are you suggesting, therefore, that by virtue of the application of Massachusetts General Laws, Chapter 40, Section 3, that local towns and municipalities have to allow these projects as a matter of right?
Interesting question, a reserved comment on it. I would suggest to you that only in the event that there's a public health, safety, or welfare protection basis could one be prohibited. And that's what it says. My way of thinking, quite frankly, is that I can't conceive of a solar project that would create any health, safety, or welfare concern. Certainly this project does not, as has been amply evidenced in the record by the independent third-party review conducted for the planning board and the site plan review process, which included a thorough review of every different possible avenue that one could claim creates any kind of negative impact.
I want to return to the theoretical here for a second before we get to the specifics of this project. I think you told me, just bear with me for a second. I think you just said that the question that I asked you was interesting and you were going to reserve judgment. The question again was, do local towns and municipalities, by virtue of operation of Massachusetts General Laws, Chapter 48, Section 3, must they allow projects like this as a matter of right? You said, well, you want to reserve judgment. And then you went into the health, welfare, and safety thing and started to get into the merits of this project. And I assure you, we will get into the merits of this project. Would you concede, however, that if there is a legitimate health, safety, and welfare issue, that the level of local concern could rise to such a significant level and to such a significant degree that a local board could simply say, no, this isn't right, it's not right for us, it's not right for this town. We are going to reasonably regulate by saying no in this particular instance. Theoretically now, do you think this board has the authority to say that?
I'm not going to engage in a theoretical discussion with you on that topic. I
Because it
would say
sounds
to
like
my
you're almost-
response to you
Yep.
that this project clearly does not provide a basis for any such determination. And I'd like, again, to go back to the independent peer review of this project prepared by Beaufort Power out of Boston, submitted in November of 2011. They looked at electromagnetic field health analysis, noise analysis, safety analysis, temperature analysis, property value analysis. They looked at screening in terms of mitigation. They looked at everything in fairly great detail. Somewhat expensive little report, 25 pages. And overwhelmingly concluded that there was not any health and safety issue. The peer review concludes that the proposed project will not likely adversely affect health, safety, and property values of abutting or nearby residents.
Okay, so
And there's one other thing that I would like to just go back on. You
Briefly,
jumped
yes.
on me with a question before I could get back to. Again, of an opinion from Kopelman and Page, who represents this town and many others in the Commonwealth of Massachusetts, recently prepared a PowerPoint presentation for the Semboa Conference on solar and wind power zoning considerations. It was just presented on May 9th, 2013. Again, in that presentation, Kopelman and Page strenuously suggested to all its clients that they needed to be very careful with 40A Section 3 and recognize that that provision required essentially an approval and not a prohibition of projects. And that if the town wants to regulate solar or wind energy, they need do so with this in mind as a baseline, and that they refer to the analogy of a religious and educational use. And oh my goodness, how about that? They revert to an analogy of agricultural use. This is something that your town has a copy of. I'd be happy to give you a copy if you'd like. But again, my point is that it's similar to agriculture, different than the theoretical thing that we talked about before. But it's similar to agriculture in the zoning sense. Because in the zoning sense, agricultural activities have been held near sacrosanct, and only under extremely unusual circumstances are you allowed in Massachusetts to even regulate that use. Essentially, it has to be a noisome or nuisance activity, the way it's conducted, in order to have an impact on how somebody goes about their agricultural use.
Mr. Johnson, let's get past whether this is agricultural versus industrial. We've had that discussion, and you and I are going to have to agree to disagree on that point. I want to take us back, though, to Chapter 40A, Section 3, which is where we kind of left off here. And it sounds to me like you're making the argument to the board that 2210 of the Carver zoning bylaws is inapplicable to this situation because it's trumped by Chapter 40A, Section 3, which provides a fairly clear-cut reference to solar being a preferred method of delivering power. So it would appear under Chapter 40A.3 that the public policy favors solar, and that you're taking the position that because of this, 2210 really is rendered inapplicable to our situation. Am I right?
I wouldn't characterize it quite that strongly, but I do agree with your basic premise that it is strongly favored, and that you know, there's a similar way to look at this that does come up interestingly in the site plan review process, and that the planning board has had an opinion from town council as a similar type of analogy. And essentially, it's citing Prudential Insurance versus America, stating that it's well-established case law that site plan review may be used to regulate but not prohibit a use. And so essentially what we're doing is the same thing. We're saying that review at a town board reviews reasonable regulation of access, site layout, design, those similar types of aspects of a project. And they review those items to help determine whether there is any detrimental effects.
So when... Yep.
So in this particular case, what I'm suggesting to you is that does not apply. I'm not suggesting that this applies. What I'm suggesting to you is that even in the event that the town would seek to create a bylaw as was set forth in the piece that I just mentioned from Copeland and Page in their May 9th, 2013 presentation. Even in the event that a town seeks to create a bylaw to regulate solar use, it has to be extremely careful because it is such a favored use, and it's so widely recognized as not detrimental.
So is this why you are suggesting in this instance that 2210 of the Carver zoning bylaws is, for lack of a better word, I suppose, overcome by the public policy as expressed in Chapter 48, Section 3?
Well, I'm not going to subscribe to your wording of it in that format. But if you want to look at it that way, it's fine with me. I think that means you're a yes vote, right?
What it means is that I want to go to the next point, which is that it sounds to me like you want this board to basically conduct another site review based on whether this project is appropriate with regard to health, safety, and welfare concerns. That we're going to need to look at this all over again on the merits with regard to health, safety, and welfare, the terminology is expressed in Chapter 48, Section 3.
No, I don't agree. I don't agree with that. What I think is that this board has jurisdiction and, in fact, the obligation to render a decision in this case that the zoning enforcement officer of the town was correct in his original determination in granting the building permit, and that he was incorrect when he revoked it. Because there is no health, safety, or welfare issue. And I'm not suggesting that you undertake an independent review, because the review has already been taken. As you mentioned at the outset, excuse me.
Not by this board, it hasn't been.
Excuse me. As you mentioned at the outset of the presentation, there have been no shortage of open public meetings to address this at the planning board, at the Conservation Commission level. What did you say? We had, planning board had, you said 5 meetings along with a site walk to deal with this issue?
I think you also just said, though, that this board has jurisdiction presently over this issue.
The Removal Commission heard it?
Has the zoning board heard this issue before, Mr. Johnson? Has it? Has the zoning board heard this issue before? Yes or no?
Well, you know
the answer is clearly no. Jurisdiction rests with this board tonight and going forward until this public meeting is closed. Are we in agreement on that? Yes or no?
No need to get testy.
Yes or no? Are we in agreement that this board has proper jurisdiction at this time as to this issue? Yes or no?
As to which issue?
As to the issue of whether this appeal should be upheld or not.
Absolutely.
Thank you. Let's address public health, safety, and welfare for a minute, because it seems like we want to continually get down to the nitty-gritty, which I think is appropriate. Okay. Mr. Corbo has asked for an opportunity to address the petitioner and the public with regard to an issue that he has.
Thank you, Mr. Chair. For the benefit of the board, the applicant, and the members of the public, I'd like to explain the way that the law applies as viewed by the purview of this board at this time. The town currently has a bylaw that does not specifically allow this type of use in the residential agricultural zone. The town further has a bylaw that says that any use not specifically allowed is prohibited. In my opinion, it is open to the Zoning Board of Appeals to uphold the decision of the building inspector on the basis that this is not an allowed use under the town's zoning bylaws. However, that decision may implicate General Laws, Chapter 40A, Section 3. And I emphasize the word may because the particular section of Chapter 48, Section 3, dealing with solar facilities, has not been interpreted by the Massachusetts courts in this context. So if the zoning board were to rule on the basis of the bylaw alone, and that appeal were to be challenged in a court, I can't sit here today and tell you how that would be resolved. And Attorney Johnson cites advice given by my firm, but yet takes it out of context. That advice is given in a general format for planning purposes. And it's conservative advice, and intentionally conservative advice. If you don't know how a court is going to rule in a particular matter, we recommend that communities act conservatively. And in fact, I stood up at the Carver Town meeting in December and gave that advice with respect to the bylaw that was adopted at that time. I did not say that if you did not adopt a bylaw, solar uses would be allowed as of right. But what I did say was that in the absence of a bylaw, there is risk that uses could be allowed in any particular zone. What we have here now is a particular application and a particular set of circumstances. My recommendation to this board is to continue to act conservatively. And while it is open to you to uphold the decision of the building inspector on the basis of the local bylaw alone, I would recommend that you take it a step further and make a determination as to whether application of the town's bylaw in this circumstance represents a reasonable prohibition of a solar project for purposes of promoting public health, safety, and welfare. In order for this board to do that, it must consider the facts of this particular case. While it's true that the planning board had in front of it at the time a general study regarding the impacts of projects in other places, the planning board was rendering a decision in a very different context. The planning board was issuing a site plan decision under the assumption that the use was allowed as of right. Under those circumstances, courts have ruled that a planning board cannot impose restrictions that have the effect of prohibiting a use that's allowed as of right. It's a much more narrowly constrained standard of review. So when the planning board considered this, the planning board started with the assumption that this project was going to go forward, but then worked backwards and said, what types of conditions or restrictions can we impose on it to make it better? This board has a very different function. This board has to decide whether the use should be allowed at all, or, to say it differently, whether it is reasonable to prohibit this use in order to advance public health, safety, and welfare. In order to do that, the board will consider the testimony of the applicant as to what the project is and what they believe the impacts of that project will be. The board will then focus on evidence from members of the community or other sources as to what they believe or know the impacts of the project to be. The board will then weigh that evidence and make a decision on the basis of that record.
Thank you. So let's address health, safety, and welfare. First, if you could give the board a general outline of the project, and then if you could move from that and address us as to why you believe this project does not have any negative influence on public health, safety, or welfare.
Okay, thank you. I refer the board to the peer review, independent peer review provided for the town of Carver for this project in particular. Dated November 2nd, 2011. It was undertaken by an independent, recognized expert
What is the date
was-
on that again? I'm sorry, I missed that.
It's Beaufort Power LLC. It is attached as...
November 1, 2011?
Oh, you need the date on it? Yes, November 2011.
It's Exhibit J in our packet.
Okay.
It goes through every conceivable potential issue for health, safety, and welfare. It was an exhaustive study about this particular proposed project. It deals with, as I suggested to you, topics of health as that relates to electromagnetic field analysis. It goes through noise analysis. It goes through safety analysis, an ambient temperature analysis, property value analysis. And it goes into some detail. And rather than reiterate the whole thing, I, by reference to this, incorporate them in my remarks. But what I would like to emphasize here is that if you look at this, you know, the summary on this was really straightforward. The summaries, and I'll read that for the benefit of the board and those here tonight. It says the proposed solar photovoltaic project would generate power from the sun by converting sunlight to electricity with no moving parts, zero use of water, and zero air emissions. This renewable energy project would contribute to national and state goals of sustainability, energy independence, and air quality improvement. Compared to other forms of generating electricity, solar is particularly well suited to agricultural and residential land uses. While this proposed project has many advantages, it does introduce new and troubling issues to some abutting and neighboring residents. End quote here, but I would like to get back to it, but I would like to point out that this study involved actually going to neighbors and abutters who had voiced some concern on the project, listened to their specific concerns, and incorporated those specific concerns into this analysis. It says, this peer-reviewed discusses a variety of such issues and concludes that, with one exception, the proposed project, particularly as revised on October 21, 2011, to eliminate the so-called Western Array Field, is well-designed and suitably sited renewable energy facility that will not likely adversely affect the health, safety, and property values of abutting or nearby residents. You can go into the history of the project if you would like, so you can understand how the project evolved from its first original proposal to incorporate sort of responses to residents from the town of Carver, to incorporate input from the Conservation Commission and the Planning Board. If that would be helpful to this commission or this board. You know, essentially, what I can tell you is that even after the project had essentially been approved by the Conservation Commission and the Planning Board, this project was, there were actually filings to seek to modify the project to try to address some of the issues raised by various abutters primarily. And what those modifications involved was to eliminate one entire field and let that continue on as a gravel pit, and also involved a pullback of the area where the where the project would be built. And these two plans here illustrate the project as originally approved and then as modified. And essentially, the as modified version has no panel closer than 120 feet to any home, and it includes a solid vinyl fence with large evergreen plantings close enough together to essentially, within a very short timeline, make it so you can't even see the fence. And those plantings are trees that will grow in height such that it would entirely block a view of this entire project from some of the surrounding neighborhoods. So those were essentially modifications that this team brought to the table, not because they had to, based on the input from the Conservation Commission or the Planning Board, but to address concerns raised by neighbors to attempt to be a good neighbor.
That it?
You have another question? You want me to go into what the difference was? You seem to wanted to,
Mr. Chairman,
Yes,
I have a couple of questions about the peer review.
go ahead.
I did read it. I'm not a scientist. But I did have a couple of questions. I noticed that the study that you used for the pacemakers and the magnetic field in relation to pacemakers and, you know, I would assume that would mean like implants of any kind, cochlear implants or any kind of electromagnetic, is dated from 2005. There was no later study. I would think 2005 is a little old.
I can answer that question. It was probably 20 years ago or more that there were a lot of concern that was generated for high-tension power lines and electromagnetic sources. And so a lot of the studies came about in those time, in the late 80s and into the 90s. And all of those studies came to the conclusion that all appliances give out electromagnetic waves. You certainly are 100 times more in danger if you use a cell phone because you've got electromagnetic next to your wave. And as they studied it, they found that even a lamp not turned on was giving out electromagnetic waves. When you turned it on, you were getting considerable amount of electromagnetic waves. And so once we got into this study, it was conclusive that if you were 3 feet away from the solar panels, you were at much less risk than if you were sitting in your living room next to a lamp. None of these panels are within 60 feet of the property line, so that it was clear that it would be imperceivable. So there was absolutely no issue.
Okay, not what I asked. I'm sorry, it was a little abrupt. It was a 2005 study. There probably weren't as many solar farms in 2005 as there are now. Are there no updated studies in relation to people with the effect of electromagnetic fields, with people with pacemakers, people with any kind of implanted device that might play off of that? This was 2005.
Okay.
Which, can you tell me where in the thing you're looking at,
It's in
please?
your peer review packet, page 13 of the peer review. It's a clinical study of interference with cardiac pacemakers. It was taken from the American College Cardiology in 2005. What I'm asking was, I can see a little note down below, it was downloaded in 2011 off a website. Was there no effort to find any more recent effects on cardiac pacemakers or implants after 2005? That seems to be a pretty significant year change to me. This is one of the biggest health issues I think anyone would have about one of these things. The same way, you know, I've been on this board 20 years, which I think makes me the most senior for that reason only. And when we first started doing cell towers, you know, the cell tower people would come to me with, you know, reams of stuff that they pulled off the internet that said this stuff is all good. And then the abutters would come to me with equal amounts of paper saying this stuff is bad. And you kind of have to learn to figure it out. All I have in this is it's good. It would seem to me there would at least be some kind of balance in a peer review that these people at least said these are the effects that they've had, and they may be minimal, but at least you showed them. And I would think that a cardiac pacemaker study, anything to do with how an electromagnetic field, my father-in-law had a pacemaker, he couldn't go near the microwave, so we all have an idea of how that works. And this would be very scary to somebody living in these neighborhoods. And solar farms are new. They may be just new to Massachusetts, but they're not new to everywhere. So is there no other study later than 2005?
There may be, and we can certainly look.
I think you should.
An electromagnetic wave, there are basically only two kinds of electromagnetic waves, and the transformers that you see in subdivisions give out electromagnetic waves. The power lines.
Okay, we don't
Okay.
need to do that part. If you get it in a study, then I can read it, and understanding the what I need to know is the effect on the people that are living in those neighborhoods. And I want to see a newer one.
A couple quick comments
Go ahead.
to try to help address your comments. The electromagnetic field health analysis that is provided here was an independent third party that was retained by the planning board. It was not part of this project team. They produced this document that has 4 different studies referenced in it, and they're included under 1A, B, C, and D, and they're all different dates. Okay?
If you're quoting it, you're embracing it, and you
Okay.
gave it to me.
Right.
So,
And I just wanted you to understand that there were 4 different studies in here, not just one. We can get some further backup on this, I guess, if you would like. And the second comment is that there is a December 2012 Clean Energy Results publication that was just put out by the Massachusetts Department of Energy Resources, the Massachusetts Department of Environmental Protection, and the Massachusetts Clean Energy Center. It's called Clean Energy Results Question and Answer, Ground-Mounted Solar Photovoltaic Systems. Be happy to submit that to you tonight as further support for our application here. But essentially, it talks about what the state-of-the-art studies determine, and happy to provide that to you.
that would be a good idea, because 2005 would not be state-of-the-art to me.
Okay? Well, this is
You know,
2000.
technology moves really fast.
Okay.
2012, we're only a little bit into 2013, so I guess it's okay.
December 2012 as well.
All right. But I'd like that as part of the record. I'd like to have copies of that submitted.
Absolutely.
Thank you.
Would you like a copy right now, or can we give it to
I
you
have to
again?
run it all off and give it to all of us. I have enough to read tonight. Thank you.
Mr. Johnson, do you have any evidence as to how projects similar to this that you're proposing affect property values?
Well, this peer review did a review of that, but I will grant you that it is primarily by analogy and by comparison purposes, somewhat like appraisers look at property values. As you know, all properties are unique, and they all have separate and distinct attributes, and so any kind of determination about values is fraught with subjective opinions that are difficult to characterize on a general basis. In other words, one person's piece of heaven is another person's not piece of heaven, let's call it. And so, in other words, everybody has a different perspective. There are a lot of people out there, and I have run into some, that would much prefer to have a solar farm next to them than a neighbor. Now, I've also learned, I happen to be one of those types of people. I've also learned through other experiences in life that there are some people who would prefer to live in a heavily developed area like a city. And they want to have neighbors, and they do not want open space, and they don't like greenery and quiet. They want concrete and glass. And I'm not going to suggest to you that one person is right and the other person is wrong. I'm just merely suggest to you that those types of subjective opinions come into the discussion of values. And what you have in front of you is a fairly solid analysis of property values by using analogy of the type that appraisers usually use.
Well, I'm sorry. Let me just follow up with this and then.
If I may, just one other point, the clean energy results package also addresses property value issues as well.
The peer review to which you have repeatedly referred and on which you seem to be basing much of your argument that this proposed project is not going to be harmful to public health, safety, or welfare, has a specific section with regard to property values. It refers to one study only, and that study, which addressed property values, addressed it in the context of rooftop-mounted solar panels. I would imagine the type of solar panels that you'd see on somebody's roof to capture sun, not large ground-mounted solar arrays. So my question to you is, if you are prepared tonight, or perhaps at a future meeting, to provide us with additional evidence with regard to how a project of this kind might or might not affect property values, because quite frankly, the section of the peer review that refers to this I find unconvincing.
Well, I would certainly appreciate the inquiry. Perhaps if I read just a couple of pieces from the clean energy results package that we'll be submitting, it would be helpful. It says, and it might help explain also why the analysis was done the way that it was by this peer review. It says, a review of the literature nationwide shows little evidence that solar arrays influence nearby property values. It does focus on roof-mounted solar because that's the only way that's all they have. It says, bottom line, and the question is exactly the question you're posing, Mr. Chairman. It says, the question, if you will, says, how do ground-mounted solar PV arrays adjacent to residential neighborhoods, influence the property values in those neighborhoods, which is your exact question. And it says, bottom line, no research was found specific to ground-mounted solar PV and property values. Residential property value research on roof-mounted solar PV and wind turbines illustrates no devaluation of homes in the area. So what they've done is a comprehensive review of the literature, and they're reporting, this is the Commonwealth of Massachusetts, DEP, Department of Energy Resources, and the Clean Energy Center. They're suggesting that there are no exact studies on point, and that's why they're using by analogy these other types of systems.
So they said there was no research available.
Right. It says that
No, what did you say? It was no research available for, no research studies on ground-mounted residential?
Correct. Yeah.
So there's no studies relating to, say, this project that we're discussing?
These folks say they could find no research on this exact topic.
Okay, so you can't say whether or not it would have impact on home value.
Well, I understand that that a person could approach it from that perspective, and that's why I went into the subjective nature of what property values are.
Okay.
What I would suggest to you is that the types of studies that are done to value real estate are they try essentially to put an objective opinion together of something that is inherently subjective. And so really what that means is that, you know, interestingly, it's all a matter of what somebody will pay for it.
Okay.
And so in the open marketplace, I would suggest to you that it's a situation where, as I suggested before, there's some people that would rather have concrete and glass and other people that would rather have something open. And so,
But they choose to move into one of those, not have it move in next door to them.
understood.
Okay, but what you're saying is that there were no studies giving support to either opinion? Okay.
Is it fair to say that there's no studies because it's not typical for a project like this to be so close to a residential area?
Well, not actually, I don't think so, Mr. Collins. I think that the problem with the lack of a study is that this is such a new thing, if you will, that there has not been an opportunity for any such studies to exist. And probably pretty soon, within the next decade or so, that kind of research will be able to be conducted, and you will find that that there are an awful lot of towns where these types of projects have gone in, and that many of the towns have had, excuse me, projects go in areas much closer to homes than this proposal. For example, well, you know.
I'd actually like to hear you for example.
Well, this is not exactly on that point. There is a bunch of towns that have started to develop, tried to develop bylaws because they are seeing what happens with the projects around. But there are projects in you know, many towns: Dartmouth, Mattapoisett, West Bridgewater. There's other projects in Carver, as you may know. So in time, there may be more information available on that, but the issue about property values is one of those things that is analyzed by sort of numbers, because in order to try to put an objective spin, if you will, on something that is inherently subjective, you need to have large numbers of transactions to determine whether there's an impact or not.
Can I just flip that, what you just said, back to health and welfare and safety? Because, well, not so much the welfare, but you're saying that large projects in residential neighborhoods is so new that they don't even have residential value studies. Could the same be said for safety? Is it, are residential arrays so new that there are no definitive public health safety studies for long-term effects to people living next to these things?
No, I don't think so. I don't think it's not the same kind of a thing because, as Mr. Reum pointed out, the only really, I mean, if you can come up with another one, we can try to address it. But the idea of safety as it relates to electromagnetic fields is something that is transferable from other areas, and so, you know, as he indicated, lots and lots of studies did get done in the 80s, 90s, and even into the 2000s about those types of issues, because as neighborhoods in the northeast corridor and the east coast and someplace in the west coast started to move closer and closer to, particularly to high power electric lines, there were concerns, and so there have been lots of studies on those types of items, and it goes all the way from the type of a power line that's already located right next door to this to you know, the studies that talk about things like you know, literally a single light bulb in a light in your home.
Again, I don't mean to belabor the point. We're not talking about power lines and light bulbs. We're talking about solar panels and arrays. And what I asked is, if you're saying that these solar farms, these large solar farms, not small ones where one person is lighting up their house or something like that, but these large ones, in residential neighborhoods sited within spitting distance of residential homes and in streets, if those are so new that they don't have data on home values, is it equal to say that they are also so new that they don't have appropriate and studied data on public safety?
No, I understand the question, and I think
Okay.
I tried to
Because- well,
address that.
like,
No,
by
I
tell-
don't,
by
I
telling
don't
me
think
about
that's fair.
power lines, I know about the power lines. People moved into their homes and the power lines were there. A solar farm was not. So I
Okay, but
want,
that's
are
you're
they,
talking
are you
about an
telling me the
aesthetic
same
change
thing?
there. I'm talking about, so I understand your question, maybe I don't understand, but I understand your question to be one that's based in science. You're saying, is there a
Can't be me
safety
asking it
issue,
then.
right? You're
What's that?
asking if there's a safety issue.
I'm asking if there's data telling me no.
Right, and
You're providing information, obviously, in support. I want to know if there's current data
Yes.
in residential neighborhoods.
Yes,
Okay.
of course. Because what it does is it gets down to that, as the chairman pointed out at the beginning, which was a well-made point, that there are some factual and scientific issues that underlie some of these items.
Okay.
And your question, as I understand it, is asking, is there a safety threat from the electromagnetic field? I mean, there's not gonna be a safety threat from somebody, like a trip hazard, because there's a big fence, right? And there's not gonna be a safety hazard from a hole, because there's no holes. So
Right.
the safety hazard, as I understand your question, would be as to electromagnetic radiation. Right? And so those are the studies that, unlike property value studies, where there's a lot of subjectivity in it,
Oh,
this is a straight scientific question, and there's gobs of research on
Okay.
that.
Okay, I'm fine, thank you.
As far as safety goes as well, not to change the subject, which direction do these panels actually face?
South.
And on this map, which is south?
Down the page.
Could you actually point it out?
Yeah, south is going down. They're running this way, perpendicular to the south.
So this way.
You want me to explain a little bit about the field? Just give you the real basics. These are rows, they're racks. We actually put pylons into the ground, support a rack, and put a whole series of panels on the rack. And there's a wire that runs in the panel, in the tray, right underneath the panel, not in the ground, but to the end of this row. So each one of these are strings that come very low direct current. You could touch it with your fingers, it wouldn't hurt you, because it's very low voltage and it's direct current. And then that's brought in trenches to a concrete pad here with an inverter, and the inverter changes it from direct current to indirect current. So it makes it into a sinusoidal wave, like alternating current, like in your house. It goes alternating in and out. Then there's a transformer that boosts it to 13,800 volts, which is the same power that's running in the power lines in the street. And now that's putting out electromagnetic wave, and it comes overhead in poles across the woods and over to Purchase Street. And that's where you would get the electromagnetic waves. You're walking along Purchase Street and there are 13,800 volt power lines. That's the closest that you're gonna come to it. So this field is putting out less in the field than is what's happening in everybody's streets. And the same thing occurs in subdivisions where the power's underground, because it comes up in transformers, and people walk right next to the transformers that are putting out 13,800 volts of electromagnetic waves. So we will give all of that to you in documented, written form in layman's terms, so you understand what the levels of electromagnetic waves and why it is not a safety hazard. I don't think in the end that you're going to be able to find that there's any safety or public welfare impact from the solar fields, because that's well documented. The biggest challenge will be for you to decide whether there's any impact on the value of the homes. There's going to be a fence that is brought all the way around the entire project. The fence is 8 foot high. We keep it 6 inches off the ground so the little critters can go back and forth. So it's 8.5 feet off the ground, and the panels, the top of the panels are 8 feet. So from the inception of the project, once the fence is brought in, the panels will not be seen. Somebody who's, whether they're on Purchase Street, on Great Meadow Road, They will not know that the panels are there. Then the trees are being kept, natural trees are being kept. There are wetlands along the bottom here, so those mature trees are being left. And the trees in the 40 feet between the fence and the property lines are going to be kept. Then we're going to implant it with Leland cypress, which is a very dense evergreen that grows very quickly. And so that's going to be a natural screen that screens the fences. So people are going to be...
How tall do those grow?
They grow like 30 feet high, and they stay very dense. Unlike white pine, they get very leggy on the bottom as they mature. The Leland cypress stay very dense, right to the ground surface.
And
So
do they thin during the wintertime at all?
they don't thin, they mesh right together. They took over from the Canadian hemlock, which used to be the choice for screening because they were beautiful and they were lacy, but a blight has come in and is going to wipe out all the hemlocks in the state. So Leland cypress doesn't have that disease problem, and they're very hardy, very adaptable. So we're implanting. We're also implanting on along this side here. Again, it's keeping a lot of the vegetation there. We found certain areas where the natural vegetation was thin. So again, we're implanting some evergreen in here. So after a few years, people won't even see the fence. They'll basically look out the backyard. They're going to see dense growth of evergreen. So they won't know the solar panels are there. It won't devalue the property.
Okay. Back to my original question on the pitch of these panels. The reason I'm asking that is as far as health issues and concerns with the neighborhood. I don't know if anybody's gone up 44 and at a specific time of the day, and you can get a nasty glare off the panels that are just right there on the highway.
Right.
And there's people that are living right on that street, and with the way that they're positioned and the way the sun actually rolls around here in the summertime, so I don't live very far away from there to begin with, so I know how that sun rolls year round.
Okay. Yeah, we
And
completed
glare
that
will be
specific
really
study.
nasty.
We completed the study for this site, for the glare. We did first thing in the morning to last thing at night, winter, spring, summer, and fall. We made diagrams and submitted to the planning board, and they were convinced, as you will be, that there will be no glare problem.
Okay, what about heat from that glare radiating through to the,
We also did an assessment of that. There's ambient temperature increase right at when in full summer, full direct sunlight, you put your hand on the panel and it's warm.
I'm not talking about the panels, I'm talking about what's radiating off
Coming
from
off of
that
it.
glare.
Right, we did that assessment as well. The panels are designed to be as efficient as possible. They're designed to
You're back on the
absorb
panels.
absorb the
I'm
light.
talking about the glare.
Right. What I'm saying is they're designed to absorb the heat, the energy, the sunshine. There is an increase in temperature right at the panel, but a few feet away, it is no warmer.
So you're gonna tell me that glare doesn't generate any kind of heat at all?
Oh, no, it generates heat. Not only does the glare generate some heat, but the panels themselves warm. You know, they're not 100% efficient, so what they don't absorb is heat, just as if...
I understand what you're saying. You're staying more controlled in the area itself. I wanna know what's happening when it's further away. I've stood next to a window 10 feet away and gotten a glare off it and been a lot warmer than if I was standing not in the direct light of it. So how much hotter is it gonna be in the backyards of these people?
Right. I'll provide you that analysis that shows you that is immeasurable. Far away, I mean, you know, at the property line, there'd be no way to with as accurate a thermometer as you could have, you would see an increase in temperature.
There's no way at all.
Yeah, it doesn't increase.
You know, also, if I may, your original question was a good one on the glare topic, having to do with the orientation of the panels, because that does affect what happens for glare. And this project is located such that the southerly side where the panels are oriented to is all wetland and gravel pit and bogs. So there aren't any residences in that immediate area. The residences are all to the northeasterly area.
I actually can see that on the map.
Okay.
And I'm looking, and I know, like I said, I know how the sun comes. the sun is not gonna be shining this way. The sun actually rotates this way in this area. And you're gonna get into an area where these panels here, and is this a road right here?
Yeah.
So you're gonna tell me that there's gonna be no glare that's actually gonna come through this road, because I'm sure you're not gonna plant evergreens right across the road.
Yes, we're going to prove to you that there's going to be no glare heading towards those residences.
None at all.
None at all.
You're guaranteeing me that. So if there's any glare at all, you're willing to dismantle the entire farm.
I'm not going to dismantle this. I will show you with diagrams and calculations that there will be no glare onto abutting properties.
I'd like to see that.
Mr. Chairman, I think that, Mr. Collins, that road that you're pointing to is simply a service road going into the project. It's not a road that any other traffic except occasional trucks going in will be using.
Have you seen how wide that road is? I've
Yeah.
been down the road a few times. I mean,
I have.
that's a parking lot.
The 12-foot wide road is what the fire department required for access with public vehicles. It's the same width as a typical driveway.
I think we're talking about two different things. I mean, an access for the fire is like 12 feet wide.
12 feet wide, yeah.
This is a lot wider than 12 feet.
We haven't constructed the road yet. On the plan, it's 12 feet, and when it's built, you know, months from now, it will
So
be.
if you're doing a 12-foot wide driveway, I mean, you cleared what, 24, 30 feet of soil from there?
We'll take about 14-foot width of topsoil out before we put the road in.
We understand that area, that particular area you're talking about was already cleared prior to this project.
Somebody cleared that prior to this
Well,
project?
I know part of that, the road where it goes through, I think, an existing home, correct?
No, this is a residential lot. There's an existing home that people live in right here. And, you know, there's a home here, and a home here. This is part of the project. You know, the home is still there.
Well, I know the homes are still there.
Right. And so there's just a residential driveway
Just
for
a
that.
little confused, because when I went down that road and looked, I seen a huge access area going through. I mean, something that's just not placed in there to try to maybe blend in. I mean, this is something that stands out.
Maybe by the power lines, you saw a
No,
road?
not by the power lines. This is more between two houses.
The,
Going down Great Meadow?
Mr. Chairman, the
Yes.
plan shows this as a 20-foot wide paved road.
This house here. And this
I know
is
it's
44
12 feet.
Mr. Collins, anything further? Mr. Collins? Anything further? I want to go back to EMFs for a second. That's electromagnetic fields. And again, I'm drawn to the peer review on which you base so much of your argument in support of this project. And I note that on page 18, there is an important statement with regard to the fact that there has not been a study or exposure threshold set for people with certain types of implanted medical devices. So, you know, by my reading here, this does not seem to be as cut and dry or black and white as you would have us believe with regard to EMFs. So I draw your attention to that. This is part of the evidence that you have submitted as part of your own package. I also want to have you...
Excuse me, could you please help
Yep. Page
us
18.
understand what you're talking about there?
Page 18, there's a statement in the peer review which indicates that...
That's part of a study, that's part of a source that's being cited? is it?
Yes, yes.
And they're referencing it
it-
against regular electric current in the, that's not a solar array?
Do you have a copy of this with you?
I'm looking at it right now, I'm trying to see where you're talking about.
All right. There is a large paragraph in the middle of that page 18. And you might want to read through that. And then at the end of the paragraph, there is that sentence from which I just quoted. Moving on, I had a question about noise that I was going to ask one of you folks to address. Again, directing your attention to the peer review, page 5 this time. It states in the peer review on page 5 that the project is expected to produce 71 decibels of sound at the property line. That's at the bottom of page 5. I want to ask if either one of you are aware that the Massachusetts Department of Environmental Protection has determined that noise of over 10 decibels at the property line can be considered a nuisance for legal purposes.
Well, I don't think that, I'm not sure where you're getting that information. It also says in here that a typical conversation between two people is 65 decibels, and a quiet suburban area at night is 45 decibels. So I'm not sure where you're getting that statistic that you just mentioned. And I'm, familiar with noise regulation, and it's, doesn't sound quite right.
Let's talk about the noise it's caused when rain strikes the panels.
If you're standing at your house, you hear it on your roof, you wouldn't hear the falling on the panels. It would only be a problem if it was only raining on the panels and not raining on the roof of your house. But to address your previous point on the noise analysis, the town peer reviewer erroneously just merely added this noise from the 4 inverters as if they're arithmetically additive, and they're not. They're basically peaks and valleys, just as AC current is. And it could be that for a split second, the 4 of them add up, and the rest of the time they can cancel each other, because if one's at a peak and one's at a valley, you don't hear anything. So we'll give you a better analysis than this. A lot of his summation was in response to the numerous reports that we gave to the town, in which they reviewed, and then he quickly summarized in his brief report. We can provide the zoning board with all of the reports.
Again, with regard to noise, the peer review, once more on page 5, states that, and we know this to be true, that photovoltaic panels themselves make no noise. They're silent. But relative to the issue of rain hitting the panels, the question that I just raised, research suggests that this has not been an issue with similarly proposed large-scale solar projects, but there's no citation. No citation to any research, no citation to any particular writings on this issue. And it seems to me that that statement is conclusory and without any support in the record. So it would probably be helpful for you to provide us with some information about any research that you can discover that suggests that rain hitting these panels is not going to cause a substantial increase in decibel levels.
Okay.
Okay?
We will do that. Our biggest argument will be that if somebody's in a house with a driveway, cars, roofs, they'll hear the sound off of that because it's so close and the panels are so far, and through the fence, the vegetation, and the distance, they won't hear any more sound, but we'll provide you that data.
And I appreciate that, but understand that we have 4 houses, by my count anyway, that are very tight to the project line. They're back.
120-foot setback to the closest home.
They're pretty close. So if we've got rain hitting those panels, let's say we have a heavy thunderstorm, we're talking over 4,000 panels that are situated in arrays that begin pretty close to the rear property line of these 4 houses. Hence my concern. So if you could provide us with something along the lines that I'm suggesting with regard to noise, particularly as it might affect those 4 houses, that would be helpful, I think. And also on the decibel issue that I raised. And also on property values. That is obviously, I think as you can sense from the comments of the board members, a substantial concern and one I think that you recognize and have recognized. Any other questions or comments? Do you have any final observations or comments that you'd like to make, gentlemen?
Right. This has been an interesting way to proceed with the hearing by question and answer. We didn't really get an opportunity to make a presentation. So it's hard for us to know if we've hit all of your high points. But rather than at this time trying to keep everybody longer, did I understand your comment earlier tonight to indicate that this board would be seeking to conduct a site visit? And if so, perhaps we could pick up after that site visit to try to address some of the concerns that you have asked for more information and otherwise give a summary at that time.
Does any member of the board wish a site visit?
I would like a site visit.
I'll be honest, I have not been by the site ever since I knew it was coming to the zoning board, and I'd like to go in with just a clean slate. I don't live near that area. I've seen pictures, but I haven't been to the site yet, and I would like to go.
Would it be you know, there are some posts out there, but would it be helpful to you if we maybe ran a tape along the edge of where the closest panels would be so you could see how far away they are from the houses and so forth? I mean, how can we be best helpful to you folks?
Well, we usually like to see a marked distance at probably the closest point, a marked distance like a stake, you know, a sprayed stake when we've done site visits.
How about if we went out with you and actually showed you where?
I suspect you'll be there, or someone, a
Absolutely.
representative will, or someone will be there.
Yeah.
And this is also something, it's a public meeting, so, you know, any persons of interest or anybody who wants to be there, we'll post the time, we'll let you know at the end of the meeting. So you're all welcome to join as well. We generally don't take any testimony, but we do just gather information.
That's the
But I would-
genesis of my question, just trying to get a sense of what other information we can provide.
Just
Yeah, where the vegetation line starts, where the fencing starts, and then where the panels are starting.
Thank you.
And just a point of clarification for the record, the site visit is not a public.
I thought it was, we've always invited the public. Okay, I'm wrong,
You're
sorry.
invited, but it's not a public
Right.
meeting, and that's an
It's not a
important
public
distinction.
meeting, but we don't keep you away. But like I said, we take no testimony, no one can walk up and talk to us.
I have one other request for you, since we're on markings and dimensions and the like. Could you measure back 200 feet from the closest rear lot line from one of those houses? Please. The lot line which is closest, I want to see 200 feet back from there. If that's okay.
Perhaps.
When you talk about lot line, you're talking about this easterly and this
Yeah, there are,
southerly.
you know the homes I'm speaking of, there are 4 of them there.
Yeah, right
I would
here.
imagine one of the 4 probably is closer to where your project begins than the other 3.
We'll just run a line right there, 200 foot for that stretch. It's easy enough to do.
And since I'm on this, and I'm curious, maybe you can help me. If you were to run a line back 200 feet from the closest rear lot line, how many solar panels would be affected?
I can't tell you that right now, but I can give you that
Could
number.
you calculate that for me?
Sure.
That would be helpful as well. Thank you for that.
Should we hear from some of the public?
Yeah,
so
we
that
will.
we know what we're looking at?
We will.
And, Mr. Chair?
Yes.
Not to interrupt, but,
I can't hear you very well, Mr.
could we
Goff.
take a 15-minute break?
Yes, we can.
15?
I was being nice to you guys. 5-minute break?
Gentlemen, before we take a brief break, do you have any final comments, or are we good for now?
What does that mean, a brief break? Till the onset, you mean?
No, no,
No, no,
we're
no, we're not
gonna,
going out tonight.
bathroom break.
Oh, okay.
Any final questions, comments, concerns?
But before we break, could you perhaps just give us some insight in what you would like to do when we come back from the break?
Well, what we're going to do when we come back from the break is take comments from the abutters and abutters to abutters.
And have we set a date for the
Not yet,
sidewalk?
Not yet.
but we
oh,
will.
We will.
We will.
Thank you.
Thank you, gentlemen. We will stand suspended for 10 minutes. When we come back, we're going to begin to take public comment from the abutters and abutters to abutters in the neighborhood. Thank you, ladies and gentlemen. 10 minutes, please.
Did you?
May I ask you gentlemen to withdraw?
Yes, thank you.
Thank you. Okay, we're back in session, and it is my intention to go until 10 o'clock tonight. It is a question in my mind, given the number of people here and given the interest in this project, whether we will be able to receive all public comment by 10 o'clock. And if we do not, we will suspend and come back another day anyway, because we're going to be doing a site visit, as you heard before we took our break. So we'll get in as much public testimony tonight as possible, and then suspend at 10 and come back at this the next go-around. Is that okay for everybody? Otherwise, we could be here until midnight, until tomorrow. So, first thing is, I want to ask everybody, please, when I do recognize them, first of all, to come to the table and to identify themselves by name and address. I also would ask that you not come up and give us a prepared speech, something that you might have written down that you just want to read to us. I respect the fact that some of us are better public speakers than others. If you want to bring some notes up and refer to the notes, that's fine, but please talk to us, not at us. We are, I assure you, very interested in what each of you wishes to say to us, and we'll give you plenty of time to say it within reason. Lastly, one other ground rule, and what's good for the goose is good for the gander, I suppose. I said, please don't clap, and you clapped for me, and that was very nice. When people come up and address us and they're done, please don't interrupt by expressing either public approval or disapproval. Again, we want to try to make this as an appropriate a proceeding as possible. We don't want to turn this into a political rally. These are not political issues. As I said, this is an evidence-taking board, and we have to weigh the evidence carefully. That includes all of your comments, but it doesn't include public acclamation or public criticism. So having said that, what I'd like to do is first ask for any comments that people who are abutters or abutters to abutters might like to make to us at this point in time. So this young lady I happen to see first. So if you could come up and again identify yourself and your address, please. Speak right up.
I've become kind of a pro at this now. My name is Michelle Cohen. I live at 3 Leland Way. And to let you guys know, you guys are kind of lucky. We've been doing this for 2 years, so for you guys just to hear this tonight.
Hi, Michelle.
It's
Thank you for
nice.
coming.
The first point I wanted to make is the independent study that you all have received by, I believe, Beaufort Power.
It's referred to as a peer review.
I'm sorry. So Mr. Berkowitz, who came out to meet with the Eastwood Estates residents when it was brought to us as a Western array as well, only met with the Eastwood Estate residents. He did not meet with the Great Meadow residents. This independent, oh, I'm sorry.
I'm sorry, is Eastwood Estates still in the way?
It is, yeah. The most of the neighborhood is the Middleborough residential neighborhood, except for like the last 3 houses in the back on the right.
That's these houses on the plan. sure what you said,
Eastwood Estates,
Eastwood Estates,
yep.
okay.
This peer review was done by a gentleman who promotes clean energy and solar energy. So, I mean, I know as a resident that had spoken to him and voiced concerns about everything. The inverter was going to be within throwing distance from my daughter's play structure. She's 4 now. She was 2 then, and I was pretty upset about it at first, and I spoke up every time we had one of these meetings. So my biggest concern about that is that he may be an independent from the town of Carver, but he promotes clean energy and like solar and windmills and that kind of stuff, and it just doesn't seem as though it was done on an even playing field.
You're suggesting that there's a bias built into this report because of
Correct.
his background?
Correct. I mean, I don't feel as though, and I know that I speak for other residents in the neighborhood, that when we met with him, we knew there was a biased opinion on this report that he did.
Michelle, have you read this report?
Yes, I have. And I don't feel as though, I mean, a lot of it is based on circumstantial evidence. He didn't have evidence newer. One of our residents' homes has 2 young men that have deep brain stimulators. I know she'll speak tonight, but there's no evidence on that that could affect their health in the neighborhood. Another piece that was a little troublesome to me was the property values. When we moved in, we were told there's going to be cranberry bogs, it's going to be great, there's going to be a reservoir, and it was wonderful. We were totally excited. I mean, picture a young couple with their little girl moving into a neighborhood that was perfect for us. You know, great neighbors, great town to live in from what we were told. And then all of a sudden, about a year later, saying, oh, and by the way, there's going to be a huge solar array instead of cranberry bogs. The gentleman that was up here that said to some people, one heaven might be different than another's. I don't know that I've ever spoken to another resident that would say, you know, if I had a choice between cranberry bogs and a solar farm, I totally would buy next to the solar farm. That's not what we signed up for. I mean, I know that it's their own property, but they're not being good neighbors in this type of project. The other thing is, he mentioned that they changed different trees because of a blight that came through and will eliminate all the trees. Well, what happens when the blight comes through to eliminate the Leland cypress trees that they put up? I mean, there's so many what ifs happening with this project that it doesn't seem clear to me that it doesn't affect our welfare, health, and safety enough for it to be able to be put into a residential neighborhood. The agricultural use that he was describing seems a little off kilter, as you guys have already said, but I just don't ever, I grew up in East Bridgewater, and it's a pretty rural town too, and when you think about agricultural things, I mean, we had people growing llamas, like farming llamas in our town. I've never heard of anybody saying, hey, I'm gonna go out and I'm gonna plant a solar field and grow solar. I've never heard that, and that doesn't seem like an agricultural use to me. So, I appreciate your time. Thank you.
Just before you leave, I wanted to respond briefly as follows. I think you heard from this board tonight that there are a number of us who are concerned with the argument that this is more of an agricultural use than an industrial use. I'm sure there will be further discussion about that down the road. Insofar as property values are concerned, I think you also heard the board express some concerns with regard to that issue, and to the credit of the petitioners, they have promised to see what they can produce with regard to that issue, and I'm sure they will address the board again the next time around. But both of the issues, the primary issues that you just brought up, are obviously concerns of ours, and I think you heard that tonight. Thank you, Michelle.
Thank you so much.
Young lady. It's an advantage of sitting in the front row, huh?
Yeah, I guess so.
Your name and address, please.
My name is Chris McGurthy, and I live at 11 Captain Hallway in Middleborough.
Hi, Chris. Thanks for coming tonight.
Yep, and I'm not prepared. I wasn't prepared to speak here. I spoke here in this room too many times. I'm the mom with the 2 kids that have the DBS. So as far as the medical concerns, I am...
Tell us what DBS is first.
It's a deep brain stimulator. My boys have a progressive neurological disorder. They were completely healthy till about the age of 10, and then their body kind of went south on them. They're both wheelchair-bound or walker-bound now.
So they have these devices implanted
Yeah,
deep
they
brain?
have, it's a wire that goes across, implanted into their brain with 2 wires that go down, and there's different leads on the wire that sends out a pulse, and you can change the pulse, the rate, 3 different things on there. So it's kind of it's a newer medical device. It hasn't been around that long. They're starting to do it more with Tourette's, different things. So it's getting more popular. They do it with a lot with Parkinson's patients and things like that.
How are the boys doing?
They're having a hard time. I mean, I was late here today coming because I couldn't leave them alone. They hadn't finished eating. So they're choking hazard. There's a lot of things going on with them. My main concern with the report that we got that I've read through, I had these guys come to my house when we were doing the study. I invited them in.
Is this the peer review that you're referring to?
The peer review, which is not a peer review. Michelle was totally right. The guys that wrote it, we knew coming in, our husbands told us, you got to watch it. They make their living with solar. They make their living with alternative energy. So they came in very biased. So we felt like we had to prove our point. So here we are, normal people. I work full-time. I have 4 kids to take care of. 2 are disabled. My husband works full-time. We're all working middle-class people. We don't have time to hire lawyers and have people research this for us. So we do as much as we can, and we have a tight group here that work really well together. But all the studies that I looked up and tried to find anything remotely related to what my kids have and what we're dealing with, and even the other kids and the other people in our neighborhood, there's no long-term studies on something like this with long-term exposures. The reports that they tried to compare my kids to were like people walking through an MRI, short-term exposures, like maybe 4 times. And you can't tell me that that's going to be a way to read what level is safe for my kids. They're going to be living next to this thing for how long? We built our house here 4 years ago, especially for my kids. It's all handicapped accessible. We moved here to make our lives easier and their lives easier and safer. And I don't feel it is. And looking through all this stuff, I did find studies that showed that living under power lines did increase your rate of cancer. And those were long-term studies. There's not going to be any studies like this on living next to something like this. It's going to be my kids and my neighbors' kids that we're going to see 10, 20 years down the line that living next to something like this has other problems connected to it, not just with the DBS, not just with a pacemaker or something. And the other thing with the house values, I mean, we're all well-educated people here. We live in Middleborough, we live in Carver, we live down here for a reason. We don't want to live in Braintree, we don't want to live in Boston, we want to live out here. So you go down Route 44 and you look at that array, and you imagine that 12 times bigger in our backyards. And tell me, okay, you got a nice fence there, so you can't see 12 feet above that, but you go up into my neighbor's upstairs house of their colonial, and tell me you're not going to look down and not see that? So you tell me, would you buy a house in this neighborhood looking down at that from your bedroom window? Would that affect how much you're going to pay for a house in this neighborhood? We don't have to wait for a study. Come into our neighborhood, look at it. When you go down Route 44, think about that 12 times bigger in people's backyard and tell me that would not affect you. Talk to your spouses, talk to your friends. See what they think, because these are the type of people that are going to move down here. I mean, you look at a study, there's different things that are going to relate into that study for the house values, the economy, all that. Just go down there yourself and think about it. Would you pay fair market value for a house in our neighborhood as you would one on the other side of Carver or the other side of Middleborough?
Just for the record, the photo array or the photovoltaic array to which you refer on Route 44 consists of roughly 330 panels.
Right.
This project is asking us to pass on 4,160. So the size is substantially different in this project than it was in the Route 44
Right.
project, just by way of background for people here and at home. Do you have
And that's
anything
not in
further to
somebody's
add?
backyard. What was that?
I said, do you have anything further to add?
No.
I
Like
do
I
ha-
said, I wasn't prepared for this. I had a lot of questions of the medical concerns that were never answered. I've been here many times re-questioning it, wanting to see the proof, the studies of the long-time exposure, and it's just not out there.
I'm sure that you're on the internet a lot, given the situation that your boys are in. Have you located or gotten any leads on long-term studies that either have been done recently or are in the process of being done?
No, nothing for long-term exposure. It's more of MRIs, because my kids can't have an MRI. They can't be exposed like that. And I've contacted Medtronics, the company that makes my kids' device, and I've worked with them, and they've put it in writing, which I've submitted to the Carver Town Hall, that there's no long-term studies. They're not going to tell me that it's safe. They're not going to tell me that it's not going to affect them, because they don't know. And this is a company that makes these devices for everybody. So if they can't tell us it's not going to be affecting them and it's not going to be safe, you know, who's the lawyer that wants to put this up and is getting paid to fight to put this up? How come he can say it's safe? Or
How
there's
close
no
is your
findings?
How close is your property line to the,
Well, we're the second house on Captain Hall when you're going down. So my backyard looks over to it. I can see the neighbors in Carver.
how close would you say the closest line of panels is to where your house is located in the back there?
I'm not sure.
Okay.
I mean, I had all this stuff before written down.
Captain
They
Hall
used to-
isn't shown on any of these plans,
Yeah.
right? That's the Middleborough entryway.
It is. I think we're on the left,
Kinda
like,
goes in and-
yeah, where the smaller box is on this side. I mean, where the power line comes out and hits Purchase Street, there's a group home there too, that has individuals that are disabled. That, you know, we have, as a society, have a responsibility to take care of them too. So,
You raise an interesting point. You say there's a group home there. Are these people with disabilities that might be affected by
they could be.
electromagnetic?
I can't disclose too much. I've been trying to work with their company, but it's different people higher up, trying to get them involved to get down here.
So you know, you have no evidence of that one way or the other?
I do know that there are medical concerns there. I don't know if they have any implanted devices. But who's to say that's the type of home that people live at and then they pass on and then new people come there? So who's to say that in the future you're not going to have somebody moving in there not knowing that this could affect them too? And most of these people are wards of the state, really.
I guess that's why they say buyer beware.
Well, these people don't have a choice, and they don't always have the best people representing them to protect their...
Anything else you'd like to say?
No.
Thank you.
Yep.
Young lady in the back.
Good evening, Mr. Chair, members of the board. My name is Renee Rhodes. I am a butter at 11 Leland Way, also Eastwood Estates.
Hi, Renee. Thanks for coming.
I also didn't have anything prepared, but based on the comments and the concerns of the board, I wanted to make a few statements. The first is in regards to the initial discussion regarding the zoning of this site as residential agriculture. As the board is aware, the applicant itself identified this project as industrial by its own choice in its initial application. The first time it decided to change that classification was when it was presented with the opposition that an industrial project should not be allowed to be zoned in a residential agricultural zone because of the bylaws, because of the characteristics of the neighborhood. So itself originally made that classification on its application. I think that that is important, and I think that the switch to agricultural now is slightly disingenuous because they made their choice themselves. The other topic I would like to address is property value. There seemed to have been some sort of statement by applicant's counsel that, you know, based on Mass General Law, Chapter 40A, that this is a matter of right, or that there's not going to be any concerns based on public health, safety, and welfare that can justify its regulation. I think that property value has been determined of welfare consideration, and I think that there is evidence out there based on other residential neighborhoods near arrays of this nature that could be looked into. There have been these residential neighborhoods built by solar farms, so to speak, and I think that research could be done to determine whether property values plummeted in those neighborhoods. And I certainly, after the comments made tonight, plan on researching it myself and hopefully coming to the next meeting and addressing that fact. I don't believe that, to a certain extent, property values are subjective. You choose where you want to live. But there is a fair market value standard, and that is generally objective, done by an appraiser. And I believe that there was testimony before the planning board that a butter from Eastwood Estates contacted a real estate agent regarding the fact that this array was going in, and the real estate agent said she compared it to being next to an industrial zone or possibly a dump. And that, I believe, should be on the record from one of the planning board meetings. I also think that there may be some bias in the peer review, as has been addressed by some of the members here. The gentleman that did the peer review clearly met with a lot of the abutters. He only met with Eastwood Estates abutters, to my knowledge. He also is in the business of renewable energy. So that should be considered in the fact that he was reviewing this. And certainly you have to have a certain expertise when reviewing something, but when your company engages in profit from the specific type of energy, you may not want to put forth very negative statements about that type of energy when you may be putting that in a residential neighborhood in the future. So those are just a few of the comments that I had based on what was said here tonight.
Stay there for a second, Renee. Old lawyers can sometimes learn from people who are lay people who have fresh views and who have a discerning eye, and I'm certainly one to admit that I've made my share of mistakes during my legal career. A point that you made that I think is telling is that apparently in their application, and can you produce the application for me, or is it in our package? Yeah. If in fact the application referred to the use as industrial, I beg your pardon?
I will get it.
Yeah, thank you. If the application in fact referred to the use as industrial, I think that's an important point, and certainly one that I will attempt to address with counsel and the petitioner the next time around. You mentioned the bias issue, and we'll continue to look at that peer review going forward. But I did want to just say for the record that the issue of public welfare, as defined by our state Supreme Court, the SJC, is considered to be a very broad and inclusive term. Inclusive in the sense that it can take into account and has been allowed to take into account such issues as preservation of property value and other aesthetic concerns. So it's a very broad term, granted. It's one that's not specifically defined, but because it's not specifically defined, the SJC has apparently interpreted it in a very broad and inclusive way, as I said. So this is why we're kind of taking a holistic look at this project and trying to determine if, in fact, there are issues here that bear on health, safety, and welfare. I think we all are in agreement that there is some concern from some quarters on this point. And as I said, we'll continue to take a look at this going forward. Thank you, Renee.
Mr. Chair, just say that labeling on the project as industrial was questioned in the Conservation Commission hearings, and it was pointed out that the state sets up criterion as far as size goes, and if it's over 250, I think it's kilowatts or what, there's a size limit. Anything over that is automatically listed as an industrial project, even though, as they're finding now, it's really classified by the state as a public utility project, not an industrial.
Thank you, Mr. Nellen. Young lady in the back.
Hi, my
Hi.
name is Diane Green.
I'm sorry?
My name is Diane Green.
Diane.
I live at, losing my voice, I have an allergy.
Just
so-
move the mic a little bit closer.
I live at 13 Great Meadow Drive, and I feel like I'm here to represent Great Meadow Drive.
Hi, good evening, Diane.
We were never approached, at least I was never approached. I heard that on Leland Way and in that subdivision, they had meetings and approached. We were never approached. We were never asked anything. Our concerns were never met. I live right across the street from the access road. I've lived in Carver 35 years. I look out my window, and it is not the same town that I've lived there for 35 years. The access road is right across from my living room. I have a lot of concerns. I'm curious how they're going to block that for me, or am I going to every day wake up, look down that access road, and see the whole solar panel array? I don't think they're going to put a fence across the access road. They have no plans to put any trees up for us on Great Meadow Drive. No one really seems to be concerned about anything. I live right across the street from the closest house to this. If I could even go up and show you on the map. Would that be all right?
Sure.
Here is the access road. I live right across the street. This is where the closest panels are, right at my neighbor's fence. Stevie, who lives there for 35 years, he looks out and he can practically touch the panel. The access road is right across from me.
Wait a minute.
Nothing was ever said about how they're going to block that for me now, as far as seeing the panels are concerned. No trees were said that we're going to plant there. They said they were going to put a fence up. I also would like to know about the house that the access road has gone down now. Supposedly it's owned by this company. What is their plans for this house? Are they going to tear it down? Are they going to abandon it? I guess now it's being rented, but is this going to end up being an eyesore in the neighborhood that we have to deal with years from now? I would like to know what their long-term plan is for this house that the access road now goes through their property. And I think as a neighbor across the street that I would have a right to know what the plans are for that. I also would like to know if there would be security lights up at night that we will have to look at every single night. I assume that they will have a security fence. Will this be an electric fence? Will this be a danger to the neighborhood? Will there be security lights up? This was never addressed either. We don't know what will be, after this is built, what are the plans for the security? Also, living in Carver for 35 years next to the high tension, we have an extremely high cancer rate in that small little area of Callow Street, Great Meadow Drive, Jowett Street, very high cancer rate. I can speak for this because my daughter now is suffering the cancer for the 4th time. She was diagnosed when she was 14. We were told a good possibility that it could have been caused by the high tension wires.
When did you move in? How old was she when you moved in?
When we moved in, she was 3.
Okay.
And we were told then, oh, high tension wires, there's no proof, there's no studies. And now it's come out, yes, they can cause cancer. I'm very concerned now you're going to add a magnetic solar field next to these high tension wires that we have running right beside that. And then you're going to tell us that this is not going to affect the health of the neighborhood and the children in the neighborhood. Just like we were told when we moved in that the high tensions would not affect neighborhood. And like I said, we've had several deaths in the neighborhood. Children, my daughter had Hodgkin's when she was 14. She is now suffering for her 4th round of a different cancer. And I think that's something that we should look into too, the possibility that we're adding even more of a higher risk to this area that already is at a higher risk for cancer rate. So that's a few of my concerns, and I feel like when you do come to this site meeting, I would like you to stand in Great Meadow Drive and look across where these beautiful woods used to be and see what it looks like now. And we did not choose to move to this area to have this. They say it's not an industrial park, but you look over there with a chain link fence and all the metal that's going to be there and all the panels that are going to be there in a big area that used to be beautiful woods and wild animals and very rural Carver, which has changed. The whole neighborhood has changed now in just a short period of time. And that will affect our property values. So thank you very much.
Before you leave, thank you for those comments, and we will take them under advisement, as they say in my business. But I did want to make one comment, and that is this. Yes, just to you, and also to everybody here and at home. You started by telling us that you folks had really not been consulted.
No, I have never been approached. I found out more information from
And
people from the
I
Leland
do want to
area.
say again for the record, that I reviewed anyway, that there have been multiple public hearings concerning this
I've been at
project.
the public hearings.
Both with the Planning Board and the Conservation
Yes.
Committee, and also one evening with the Board of Selectmen. So I don't want anybody to leave here tonight, or people might be watching at home thinking that somehow this project sprung virtually fully developed overnight on everybody, surprising the neighborhood and the town. As I said, there are multiple public hearings. Now, you may not have been specifically spoken to when folks went out there and canvassed the neighborhood, and if that happened,
what I
that's
was
certainly
referring to.
regrettable.
That's what I was referring to.
But I do think that certainly the town has spent almost 2 years on this project, and now it has come to us after all of this time. Thank you. Gentleman in the back.
Good evening. Name's Eric Tobalski. I live at 3 Leland Way.
Eric, thanks for coming.
Thank you for taking the time to hear us. A number of comments I'd like to bring up. Some related to the peer review. Within the peer review, the EMF was a big focus as far as health is concerned. The study that was cited in there, digging a little bit deeper and reading the whole study, it almost seems like certain passages were cherry-picked out of the study that backed up the opinion that he was trying to make. If you read the study, it also mentions that there were issues of problems created with the pacemakers that were studied as a result of the electromagnetic field. Maybe they were small numbers of instances, but still, it was noted that that happened. Hardly a real overwhelming support that there's not going to be a problem. That goes back to the language that was used in the report as well. Virtually everything that was studied and attempted to be discredited, the language was along the lines of not likely to be a problem. It really wasn't any conclusive evidence. And the fact of the matter is, you've got an attorney performing this peer review. He's not a doctor, and he can read these studies, but I mean, who do you trust more to make your medical decisions, a doctor or an attorney? I know I'd trust a doctor a lot more on that. You take a look at Chris McGurthy, whose sons have the deep brain stimulators. The patient guide that she shared with me for that was published after that study was, and specifically mentioned that with this device implanted, you should stay away from sources of electromagnetic fields, including power generation facilities. Certainly what we have here, and there's certainly a lot of different kinds of electric generation facilities. Who knows where the problem is? They can't seem to say one way or another. Certainly, taking the fact that they're telling you to stay away from that with the language and the findings of the report that was the study that were cited in the peer review, it seems like there is certainly concerns there that haven't been addressed. Similarly, with the welfare related to property values, as was mentioned, there's no studies out there for such a similar project as this one. One of the studies that was cited was the wind turbines. Certainly comparing apples to oranges here, I know that. But you dig deeper into that study as well, there were very few homes that were really close. Within a mile is what they were defining as close to the projects. Those that were within a mile certainly had impacts on the value by that. Certainly, excuse me, certainly, like I said, comparing apples to oranges, but there's a lot more homes within a mile of this project than were even studied in the report altogether. All along, that seems like it's something that needs a lot more research before it can be proven one way or another. Another issue that concerns me kind of relates to both health and welfare. Take a look at the project on Route 44. I'm sure all of you have driven by it at some point at night since the thefts had occurred over there. It's lit up pretty well at night now. We were told at the last minute, oh, by the way, this project might have lighting on it. We don't have any information as far as where these lights would be or anything like that. Taking a look at what Route 44 is and the fact that it's 330 panels compared to almost 4,200 panels as proposed here, one can imagine that there'd be a heck of a lot more lighting there. Hard to sleep when you have that much light potentially shining in your back window at night. And it can certainly lead to health and mental welfare problems at that point. Now moving off the peer review, it certainly sounds like the majority of the board is having a hard time accepting that it is an agricultural project.
Let me interrupt you just for a second.
Sure.
Don't assume by the tenor and scope of my questions or the questions of any other member of the board what our vote is likely to be.
No, I wasn't trying to make that
That is a
conclusion.
dangerous enterprise. I've tried to do it many times with judges, and I can't predict, even though the questions might sound and the comments might sound sympathetic. I think counsel will agree with me on that point. Judges are hard to read. We are judges of these facts.
All right, noted.
We're trying to find facts and arrive at the most appropriate decision based upon an application of appropriate town bylaws and state law. Okay?
All right, noted. So as far as the town bylaws are concerned, certainly there's a lot of gray area in there. I mean, the fact is that the bylaws, as was mentioned, they do say that if it doesn't fit into something that's approved, it should be denied. State law is the only thing that calls that in a little bit into uncertainty. You go above the state law to the Supreme Court, and Ambler versus Euclid, 1926, if I remember right, said that you have the right to separate the dissimilar uses. Regardless of what you want to classify this type of project as, it certainly isn't fitting with what's already in the neighborhood. And the type of setbacks and whatnot don't come anywhere close to what would be expected. We in our bylaws, we don't have the specific instance of a industrial project built in the RA zone at the time the project was initially submitted. However, when we do have projects that are in an industrial zone abutting a residential zone, there are requirements for increased screening. None of those requirements have been met here. All throughout the bylaws, it's just one after another issue where it just doesn't meet our bylaws. The access road was mentioned. You've got the access road on a lot on Great Meadow Drive, which doesn't look like it's a 60,000 square foot lot like the bylaws require now. Doesn't look like it has 150 foot of frontage. Non-conforming lot, and they're going to chopping off a good chunk of the property for this access road through the lease. And what does that do as far as non-conforming lots? That seems like something that shouldn't be allowed altogether. And just briefly, I'd like to touch on Mass General Laws at 40A Section 3. There's some distinct language differences in there for the solar projects versus education and agriculture. The education, the agriculture language is a little bit more clear, a little bit stricter, that basically says that you have to allow this everywhere. That language is absent from the solar projects. You start taking a look at what's been done elsewhere in the state with the solar projects. These large projects like this are fairly new around here, the last few years, really. And in those last few years, you've had Sturbridge, the selectmen, got a moratorium in place under Copeland and Page's assistance, basically stopping all of these until such a time that they can get a bylaw in place. You've got West Bridgewater, where the Zoning Board of Appeals recently denied a project the right to build, basically because the opinion was this is clearly an industrial project in a residential area. And then you've got Holliston, which also denied a project at the planning board level. All of those towns denied them. None of those have had court challenges. You take a look at what's been done with the bylaws. As you know, we've had a bylaw that came into play after this. It doesn't allow this project everywhere. Village, for example, has a no for these kind of projects. The Attorney General approved that. You take a look at other communities, the Attorney General has approved a lot more restrictive bylaws that essentially prohibit the projects such as this from large areas of town. It seems like we're in an area, certainly is a gray area, but the Attorney General seems to be supporting the right of the communities to really restrict where the large projects like this can go.
And therein lies the tension in this case, because it certainly appears from a fair reading of Massachusetts General Laws, Chapter 48, Section 3, that public policy favors the development of solar energy. On the other hand, the Attorney General is giving some towns and municipalities space to regulate and/or prohibit, in my judgment, based upon health, safety, and welfare concerns. So it's a difficult and complex balancing act that has to be performed here. And evidence is key, as I've pointed out many times already this evening. Part of the problem is that this solar energy is so new in the overall scheme of things. This type of array, this type of project is so new in the overall scheme of things that we don't have many long-term studies on such issues as property values and definitive studies on EMF. So I recognize your points, all of them well taken. Do you have anything further you want to say?
It just seems like at this point, so many pieces of evidence that don't paint the clear picture one way or another. Our bylaws do paint the clear picture, though. It seems like that's what we should be deferring to, is our bylaws that are in place. And
I think all three attorneys in the room agree that The zoning freeze applies in this case. Mr. Corbo, would you agree again that it does apply? So in this case, the solar bylaw that we have in the books now, Mr. Tobolsky, is inapplicable to this
I'm not
situation.
disputing that. What I'm stating, though, is that the bylaws that were silent on solar, you know, they do make it clear that only certain uses are allowed in the RA zone. I fail to see how this meets any of those requirements.
Because Chapter 40A, Section 3, state law, says that towns cannot unreasonably prohibit or regulate
But then we go
solar.
beyond that to the
So state law trumps the local bylaw.
and the Supreme Court decisions trump the state law, which state that you do have the right to keep your dissimilar uses separate, as our bylaws do.
I don't think we're disputing that point.
Thank you.
For your comments. Thank you for coming tonight. Who's next? Yes, sir.
Chris McCaffrey. I live at 71 Purchase Street.
Thanks for coming, Chris.
First, I'd like to say that the safety concerns that the residents have are not just related to EMF. The pylons they're using are about 12 feet high, and they're going into our aquifer that we're drinking that water that they're pounding into. They have an inverter and a transformer. They use toxic oil to cool the transformer. There's been plenty of documented cases of transformers blowing up. I'm concerned about that oil leaching into my drinking water, as are all the residents. The panels themselves are made up of heavy metal things such as cadmium and lithium, and they're put together with lead. And there's a risk, it might be small, but there is a risk that those things leach into our drinking water. We shouldn't have to face that risk. That's why we have zoning bylaws that protect residents from being next to commercial operations that could basically kill us. And we're looking for the town to protect us. And that's the job of the planning board, was to protect us. And they didn't do that because they said it was as of right development. So from the very first meeting, they told us they could not stop it. No matter what we said, whatever evidence we presented, whatever anecdotal evidence, anything we presented, nothing was going to sway them from stopping. All they could do was make some regulations about the size of it or setbacks, and meaning nothing to us because we don't want it there. I had some other points, but I forget.
Take your time. You're doing great.
I'm not. I'm nervous. Bottom line is, I think our previously existing zoning bylaws pretty clearly were trying to protect citizens. That's what the citizens voted, to separate uses, and this is clearly not a residential or agricultural use. It's a use that doesn't belong there in that neighborhood, and I hope to hell you stop it. Thank you.
Well, before you run,
I told you, I'm nervous.
maybe some of my comments will jog your memory. Do you have well water?
I do. It's 12 feet deep, same as the pylons going in.
The well point's 12 feet down?
It is 12
Is that
feet.
standard for the area over there?
That's pretty
Yes,
typical.
they're all shallow wells.
Now, I'm flipping through pages here, and it's getting late, and I can't remember myself where I put this note, but I seem to recall that one of the modifications to the original planning board review that was adopted by the project folks was that they were going to use some kind of less toxic material in the inverter, and I see them nodding over there affirmatively, so I think I've hit the right point. Were you aware that they apparently have been asked to and have agreed to switch to using some sort of non-toxic material or fluid in the inverter that would not cause any concerns with regard to ground pollution?
I would ask them, would they drink it? They're telling me it's non-toxic. I don't believe it. Is it vegetable oil?
Is it non-toxic or less toxic?
Yeah.
Is it non-toxic vegetable oil?
Okay. And just one other comment by way of clarification. None of us was present, I think, at any of these previous planning board hearings. So as I said at the outset tonight, we come into this fresh. We start from scratch. If the planning board was under the assumption at the time that, you know, all they could do was approach this from the standpoint of producing the best site plan review with the most appropriate conditions, then, you know, that was their judgment. Our board, as Mr. Corbo pointed out earlier, has sort of a different scope and approach. We are listening, I assure you, as we listened tonight for an extended period of time to the project folks, and they were entitled to that time just as all of you are entitled to this time. So I hope that when you all leave here tonight and when you join us again the next time, you'll understand that we are doing our level best to weigh all of the factors, listen to you. In the end, someone is going to be unhappy here. You know, this has come down to a situation where it appears as if the project folks want to go forward with the plan as previously approved by the planning board, and certain segments of the town, and most especially this neighborhood, is vehemently opposed. So these are difficult cases and difficult decisions to make, and we'll do our best.
I just remembered something. Anecdotally, there was a resident whose last name was Morton, and she testified that she had a signed purchase and sale. She had a real estate agent at the meeting as well. She had a signed purchase and sale, and the buyer backed out when they found out there was a solar farm going in. And I think that's going to happen to everybody who butts this thing.
Well, since, again, evidence is so important to this board in achieving an appropriate and balanced decision based upon local bylaw and state law, if there's anything that anybody wants to bring to the attention of the board at the next meeting, including any letter along those lines that would help us come to grips with the property value question, which has been raised tonight from various quarters, that could be helpful.
Do you have access to the previously submitted testimonies and stuff in the other meetings?
I don't know. We'll have to check.
I think we can get the minutes, and however the minutes were written and approved, it depends on what was in them.
And I would caution you as well that if what shows up in the minutes, if anything, is hearsay, in other words, this person heard it from somebody else, but it wasn't coming from that someone else's own mouth, that evidence is generally considered to be less probative or less reliable than if the information were to come from the person who was actually affected. So if that person wanted to come in and talk about what happened to them or provide a letter, that would be
That's what I'm saying.
that would be helpful.
Letter.
Okay, I've never seen it, and I'll ask our clerk to see if she can locate it.
Okay, thank you.
Thank you, Chris.
It was submitted to the planning board, to the planner? Okay.
One night we were all handing them in,
During the planning board meeting?
All right, I observe that it's 10 o'clock, but I also observe that there's a hand up that I would like to call on. So let's make this one the last one for this evening so we can all go home and get some rest. And have the Bruins won the OT? Overtime?
Technology these days.
Okay.
James O'Brien, 4 Great Meadow Drive.
James, thanks for coming tonight.
Thank you. I'll try and be as brief as I can, and after 2 years, there's so much redundancy here, it's kind of hard to know what's been overkilled and what hasn't. But I know there are a couple comments that I'd like to make. One of them being, and you sort of directed to this a while ago, I work very hard. I worked very hard all my life. And unfortunately, like most people, most of the money that I have goes into my home. And that, therefore, makes my home my welfare. Because without my home, I don't have much of anything. And to say that something like this isn't going to affect our property values is sheer absurdity. There's absolutely no way. And I think in that context of trying to find that letter, if I understand correctly, Miss Morton and her either husband or fiance had to walk away from that home after months and months and months of trying to sell that and needing to move. And if that has any impact on the fact that that affected their property value, I'm sure I can speak to her and try and find some information on that as well. As to the rain effect on the solar arrays, it was mentioned that the sound on the roofs would be similar to that. I know that my roof is not 5 to 7 acres, and I think 5 to 7 acres of solar cells are going to have a much louder impact than the roof of my house. And where the measurements came from must be some sort of strange Canadian conversion, because when you go out there to see the distances, I don't know where they get those distances from. There is no way that those distances are accurate from what they're stating. And if you put up an 8-foot fence with cypress, regardless of that, we're talking about split level ranches. So you're not talking about a 5-foot person walking down the road. You're talking about a 5 to 6 foot person standing up on a deck that's 5 to 6 feet up in the air. So they're going to look over that at a humped land at a sea of solar fields. And that's not what anybody in this neighborhood bought into. We did not move to Brockton. We moved to an area that was different than that. And this does affect our property values and our lives. And ultimately, I guess you could say it's affected our health, because for years we've been working on this and losing sleep and not being able to live our lives the way we want, because this has succumbed so much of our time. And to try and come to an end, because I know I had another point, and I don't want to take your time uselessly, it would be posed as a question, because I know that you said, as 3 attorneys in the room, that this is you're a judge in this sort of case. And I'm not sure how this applies, because this isn't a criminal case, but I know that in our justice system, that a reason of doubt keeps the innocents free. And as neighbors, this is not a good business move. This is not a cooperative neighborly move. And we are the innocent parties in this. And I think that a reason of doubt has been proven enough to say that something like this is not appropriate and not just in any way whatsoever. And as a judge, I think that any judge should agree to that context. Is everything that's being said proven? No, because there is no evidence. It isn't there. But we should not be the guinea pigs to be that evidence. And I think our bylaws protect us from that. Thank you.
Just a couple of things in rejoinder before I let you go, and
sure,
if something else pops into your mind after I'm done, feel free to address us. First, the standard of proof in criminal cases is guilt beyond a reasonable doubt. It's not a criminal case, it's a civil case.
Right.
So let me clear up that point. With regard to the issue of property value, you know, you heard me address the last person and suggest that that letter be produced from the woman who lost the deal on the house, allegedly because this project was going in. Likewise, I would suggest that if anybody has any report or letter or evidence that they'd like to submit from a qualified appraiser or real estate broker with regard to the effect of property values on, or the effect that a large project of this kind would have on property values, we're certainly prepared to accept it as part of the evidence in this record. So I throw that out for people.
I mean, I know, I understand it's all different councils here that we've been dealing with, but we've been submitting these letters for 2 years now.
I'll have our clerk look in the file.
I have everything at home, I've kind of put it away. Not
I
that
tell you what,
I had enough copies.
just in case we can't find it, because we don't.
It's from Nancy Overman, she's a real estate agent in California,
Oh.
who's been dealing with solar arrays like this.
Okay, and it might be useful for this board as well, keeping in mind that the author of your report lives 3,000 miles away and probably is not as familiar with this area. Hold on, just let me finish. That it could be useful to get a report from a local broker or two, or appraiser. So, yeah, if these things exist, would you please bring them to our attention? Because it would certainly help us as we take the evidence and consider it and weigh it in this case.
Could I just briefly finish out with one more thing? Thank you for the time and the reflection, because, you know, in context of the peer review that was presented, you know, again, it's been stated a few times, but most of the language in there is vague, and not likely is not a convincing argument for myself. I became involved in what's happening in this town because of this incident, and that's not because anybody on Great Meadow knew anything about this. They never received a letter talking about solar. They received earth removal letters, period. And the only way we knew about this was when the Eastwood Estates residents came over and informed us what was going on. And that's when we started attending the meetings and realizing what was happening. We had no idea before that. There was no direct contact. This is not the first solar company that's put through a proposal on this project. Other companies have walked away from this for various reasons, hopefully because they realized it was not the right thing to do. But that peer review that was presented was argued quite often, and as I became involved in this, I became a lot more involved in what's happening in this town. I'm a member of the school committee. I was also a member of the solar bylaw committee, because to me, it was clear that something was necessary that needed to be created, and I wished to be a part of that, seeing how things had gone prior to that. As a member of that solar bylaw committee, the writer of the peer review spent time at that solar bylaw committee labeling myself and another resident who took our time to be involved in this as solar heathens, verbatim. Solar heathens. Because we were against a project like this going into that. And I beyond insult taking from that, it was a very controversial meeting that we had that day.
Is this the author of the report, Mr.
Berkowitz.
Berkowitz said that to you?
Yes. Myself and Mr. Tobolsky were both members of that committee, as was Mr. Nowen.
Okay, well,
To me, what that does is
yeah, go ahead.
I mean, that takes away the validity of what he's doing. It's clear that there was a bias in what he was saying. In no way am I a solar heathen, and insulting for him to promote something like that just shows that his point is not towards what was right and what was wrong. It's what the agenda was moving forward, and that was to get this approved.
One other suggestion that I have for those of you who have talked to us tonight and may want to talk to us the next time and who have an interest in this case, it might be a good idea for you to submit photographs taken from the rear of your houses or upstairs decks so that we can visualize for ourselves, because obviously we're not going to be going up onto your decks or porches unless you want us to and you have pizza ready.
I'm sure our neighbor will allow you if you're going through a walkthrough.
But in any event, things like this, you know, the photos, the appraisals, letters from qualified real estate folks, these kinds of things would be helpful for us to come to grips with the property value issue, which has been discussed so significantly tonight. Mr. Ryan, any final wrap-up comments?
No, I think you're just facing not a resistance with that, but this has been done for 2 years, and we weren't sure that that's what we were coming here needing to present and needing to have. So if there's any lack of that, we'd apologize. But again, this isn't first time around for us, so it's been an exhausting experience.
I can sense that among everybody who's spoken. It's almost something like you've said it before, I'm saying it again, saying it to someone different. But, you know, we knew this was probably going to take extra meetings, so, you know, the opportunity is still there. And you know, we wanted to come into this, the zoning board wanted to come into this as a blank slate, so we didn't ask for the planning board information or the minutes or anything. We want to come in here and be able to get it for ourselves for the first time. None of us are abutters in that neighborhood. You know, Mr. Collins lives close by. I can't say that any of us attended any of the original planning board meetings. I know I didn't. Might have seen them on TV, but not watched them carefully, and certainly not with the passion that's what's being shown tonight. So if we're asking them for you, I sense the frustration. It's like, I've done that. We're just asking for you to do it again one more time, and we appreciate it.
Wow, I appreciate your time and concern here.
Sense the frustration in all of you, and you know, I'm sorry for that. But
Thank you, Mr. O'Brien.
Thank you.
As the hour grows long, let's talk about when we can do the site visit and when our next public meeting will be on this particular petition. First, the site visit.
June 8th?
Unavailable to me. I have 2 Saturdays in June, the 1st and the 15th on my schedule.
You can do the 1st?
I can do the
Our
1st.
next meeting is the 15th, unless you want to push it back a week.
That's probably going to have to get pushed back. But let's talk about
schedule
the,
the 15th?
wait a minute, let's talk about the site visit first.
Well, our next meeting is scheduled for the 13th. Do you want to push that back and then do the site visit on the 15th?
I think it depends on the schedules of the other board members as well. I can't hear you, dear.
they both work for me.
They both work for you.
It's going to be the morning, correct?
Yeah. Mr. Nowen?
I'm not sure, but I probably can make it work.
Either one. Mr.
Both
Maynard?
work for me, yes.
Yes. Mr. Mueller?
1st and 15th is okay for me, so.
Ms. Clark?
Sadly completely available.
It's okay.
Mr. Collins?
The 15th, excuse me, the 13th works?
No,
13th?
1st or 15th?
No,
First
go-
or
go to
This is
June.
for the site visit.
Okay, then the 15th works.
But not the
is
1st.
kinda iffy.
Okay. So if we do the 15th, then the next public hearing will take place in July. Because of my schedule. I will be away the last 2 weeks in, the last 10 days in June and part of the beginning of the first week in July.
Okay, so our meeting for July would be July 11th.
Yes.
And I'd like to point out, there will be no other public notice. I mean, the agenda and the notice will be published at the, in the, you know, the bulletin board, the town hall, and on the website, but you won't receive a letter. The dates that we set here is, this is your notice. You're not gonna be getting another letter or anything. Yep.
I'm sorry, can I ask a question? On the site meeting on the 15th, do you have a time that you'll be doing it, or is it any time during the day, or?
We're working on it.
We're working on it.
We do it random.
Yes.
Oh, yeah, no.
You're gonna know in about 1 minute.
Okay, unless you have to go now. Give us a second.
10 o'clock?
Do you have a question?
9, 10? Which do you prefer?
9, earlier the better.
Ms. Clark, you have an unhappy face. Can we compromise at 9:30?
I didn't have anything to do, didn't mean I wasn't gonna be.
Can we compromise at 9:30?
9:30 is
Bring it.
15th at 9:30?
Yeah, I'll bring coffee.
Gentlemen, 9:30, okay?
9:30 is 15?
Yes. Yes.
And where shall we meet, guys?
By the power lines, perhaps?
The power lines?
Yeah.
Access,
Great Meadow Road and
Maybe they
Power
would
Line.
tell us the best place to meet.
the access road on Great Meadow?
Gentlemen,
Gentlemen, where would you like us to meet you?
excuse us, gentlemen. We're
You guys,
asking a question.
where would you like us to meet you? So we drive up Great Meadow to the power line? Okay. So
Follow our
Tony Boyd, this way.
Okay, so we will have a site visit on June 15th at 9:30, and we will continue this public hearing on July 11th, and we'll continue, ladies and gentlemen, and the folks at home where we left off tonight, which is in the middle of the public comments section. I suspect that there are probably some other folks tonight who I did not get to. I see at least a couple of people nodding affirmatively. The people who will go first the next time are the people who are the neighborhood folks, the abutters and abutters to abutters, and then we'll take comments from people who are a little bit further away, who are Carver residents and/or Middleborough residents. So that'll be the order when we reconvene the next time.
And we should have all the information that we asked Debbie for, right? But July 11th, I suspect it'll be up there again.
Okay. And as a courtesy and a show of good faith and fair play, I give the petitioners a very brief opportunity at this time for rebuttal, if they choose to want to take that opportunity. Oh, at the very end, I guess. It's being suggested at the very end. Okay. Yes, right. That's what I meant to say. I beg your pardon? Yeah, at this point, it's too early for us to know whether there are going to be any other cases coming in. And I certainly hope not, because, my goodness, I'm going to have to shave again. So, having said all of this, and I think having everyone understand what the next stage and stages, I should say, of these proceedings are going to be, I ask for a motion to adjourn at this time.
I so move.
Second?
Second? Not
Yep.
second.
What do we?
Schedule, you gotta make a motion to schedule a site visit, you have to make a motion to continue the public
Okay.
hearing.
All right. So, motion to schedule site visit
I so move that.
for the date of?
June 15th at 9:30.
Yeah, that's the one.
What she said.
Second?
Second.
All in favor?
Aye.
And do I hear a motion
I
for
move
the
we have
next
another
date?
Continuing meeting, July 11th, 2013, at 7 p.m.
Second? All in favor?
Aye.
Who wants to make a motion to adjourn, please?
You're on a roll.
Yes.
I'll make a motion to adjourn.
I'll second.
All in favor?
Aye.
We are adjourned. Thank you, ladies and gentlemen.
Thank you.
Thank you.